All right, Mr. Fleming, you're here for Fluid Chillers Inc., MSI versus MSI Automation and David Brinkenhoff.
Yes, Your Honor. Thank you.
All right, I have an indication that in your, I'll call it. Let's see. I'm trying to see. I initially had no proof of service for your for this file, and then there seems to be a late proof of service filed February 1st that was filed to Mr. Brinkerhoff.
That is correct. We recently filed a proof of service. The original subpoena was served on January 9th, but then we originally scheduled to take place on January 31st. And then prior to that, the court adjourned until today. And I emailed Mr. Brinkerhoff the updated notice and time to appear for this morning. She responded and acknowledged, and the proof of service recently submitted contains both the original proof of service on the subpoena as well as the service of the notice to appear for today.
All right, so you had contact with I have David Brinkerhoff of MSI. What name did you indicate? What name did you indicate?
Mr. Brinkerhoff, correct, the same name.
All right. All right. All right. So this is, I'm going to go ahead and put your proof of service in here. So this is the time set. So I'll call to the record docket 2200509 GC. That's Fluid Chillers Incorporated versus MSI Automation Incorporated, and David Brinkerhoff as representative. Will the parties please introduce themselves for the record? Mr. Fleming.
Good morning, Your Honor. James Fleming on behalf of Fluid Chillers.
All right. And I checked the Zoom courtroom. Sir, on the iPhone, would you please identify yourself?
Isaiah Thompson.
All right, Mr. Thompson. And do you have the number for your case today? I don't see you on my docket.
No.
Do you know who your lawyer is?
It's not under email. I'm gonna look back.
It's under a email somewhere.
All right. Well, stand by. You're not the person I'm looking for. So I don't see Mr. Brinkerhoff in the physical courtroom. I don't see him in the Zoom courtroom. There does appear to be valid service on the matter. Mr. Fleming, this was a time set for discovery in the matter. How would you like to proceed?
Thank you, Your Honor. As you mentioned, we were scheduled today. We subpoenaed Mr. Brinkerhoff for a debtor's examination and for him to produce certain documents, as he has not appeared this morning, neither in person nor on Zoom this morning, nor has he contacted my office. We would request a bench warrant be entered at this time.
All right, what I'll do is, there were some problems with service, but the service was made. I'm going to issue a show cause to Mr. Brinkerhoff to explain his non-appearance today. And if he fails to appear for the show cause, then I'll bench warn him. All right, sir?
Very good. Thank you, Your Honor. We will,
all right. So
will the court nail out, that notice to here, or shall we serve that on his as well?
I think you serve the show cause on him. That doesn't come from our department, does it, or does, yeah? So you would submit it to me to sign the show cause, and then our civil department will assign a date for the show cause for him to come explain himself, and you'll get notice of that.
Very good, thank you, Your Honor.
All right, so I'm gonna show cause. Go ahead.
And Your Honor, you had mentioned, after we submit the show cause, the civil department will enter the date, and then they will provide that notice to Mr. Birkenhoff and my office as well.
That's correct. That's my understanding is the date, since we don't set the civil on my docket, the show cause will actually come from the civil department, but they'll provide, then once I sign the order, you'll get notice of that date through our civil department.
Very good, thank you, Your Honor.
All right, thank you, Mr. Fleming. Anything else for docket 22-00509?
No, Your Honor, thank you.
All right. Have a nice day.
So do you want Mr. Rathbun to put in a breakout with his attorney?
All right. Mr. Rathburn, two things. One is you probably shouldn't smoke in the Zoom courtroom, all right? So that, yeah, Mr. Rathburn,
Yeah.
you shouldn't smoke in the Zoom courtroom. That's the first thing, all right, sir?
All right.
Second thing is I'm gonna place you in a breakout room with your attorney so you can discuss the case with her, all right?
Okay.
All right. So will that be with Ms. Robinson? All right. So I'm going to place you in a breakout room with the public defender, Erin Robinson. She's in room 2, and you should get a prompt to go to room 2.
All right.
Mr. Rathburn, did you see a prompt to go to room 2?
No, I don't.
You might go to breakout rooms on your device or more.
is still on Zoom.
All right, Mr. Thomason, I'm trying to figure out what case you're on. You can unmute.
Noah Alvarez.
Noah Alvarez. Oh, were you subpoenaed by the prosecutor's office?
Yeah.
All right, stand by. You're in the right place, Mr. Thomason. I now know what case that you're here on.
Okay.
On the Tino U616AT, can you identify yourself? On the cell phone moniker Tino U616AT, can you identify yourself?
Michael King.
Yep. Michael King, you're here for your 9 o'clock?
Yes.
All right, you're in the right place, sir. Stand by, all right?
All right. Thank you.
I honestly don't.
Sir, from the Ingham County Jail, would you identify yourself?
Dave George.
All right, thank you, sir. We'll call your case in a minute. So, Mr. Thomason, I'm going to place you in a breakout room with the assistant prosecutor, Miss Gallagher, all right?
Okay.
All right.
Hello, I was
All
put
right.
into a breakout room with Mr. George, but I need a breakout room with Mr. King. Sorry about that.
All right. So let's put you in a breakout room with Mr. King, and we'll put Miss and All right. And we'll put Mr. Thomason with Miss Gallagher. Mr. Rathburn asked for help. He probably wants out.
Well, it was just out. I don't know. I went back in there.
Your Honor, Matt Nagel here on behalf of Haley Thomas. When the prosecutor is available, can I get a breakout room with the prosecutor as well?
Absolutely. So she's talking to a victim now. When she
Okay.
comes out, I'll make it brought to her attention that we're going to put you in a breakout room with her.
Thank you, Your Honor.
You're welcome. And Mr. Rathburn, you're a public defender in another breakout room with another client, so just stand by, okay?
Okay.
Miss Gallagher, are you all set with Mr. Thomason?
He left abruptly.
If she wants to speak to this.
All right, I don't know what happened to Mr. Thomason. Did you want to speak with Mr. Nagel in a breakout room while we have him here?
That would be great, Judge. Thank you.
All right, so I'm going to have Miss Gallagher and Mr. Nagel placed in a breakout room.
Thank you.
So Miss Gallagher, you can go back to room 4, and we put Mr. Nagel in room 4.
Okay, thank you, Your Honor.
All right, Mr. King, you're out of the breakout room. You can mute yourself. With the individual on the Alcatel Joy tab, please identify yourself. Sir, you're in the tie.
Bradley Shaler.
Randy.
For pretrial. That's because yes, it was. You were right. It was scheduled today,
What's his?
but it was removed.
All right, Mr. Shaler, you're in the right courtroom. Just stand
Yeah.
by. All right, we've got some cases to call in front of you.
Okay, Your Honor. Thank you.
Mr. Thomason, are you back?
Yeah, I got disconnected from the break
All
room.
right. The APA is in a breakout room with another lawyer, so I'll put you back in a breakout room with when she returns, okay?
Okay.
All right, we're on the record in docket 22-02896. Mr. Rathburn, that's your case. So you should unmute yourself. You can unmute yourself by *6, Mr. Rathburn. Or just on your video monitor. There you go. All right. So on the record, docket 22-02896. People of the state of Michigan versus Daniel Rathman. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Ailish Gallagher on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Rathman.
And sir, you are Daniel Rathman?
Yeah.
All right. This is a time set for a pretrial in the matter. Ms. Gallagher, how are we proceeding?
Thank you, Your Honor. After confirming that the defendant has gotten all 3 dogs licensed, the people would move for dismissal.
All right. And let's see, is this on a ticket or a complaint?
That is a good question, Your Honor.
Let's see. It is on a complaint, so we should do a nollie. D completed compliance. And people move to dismiss. I'm assuming there's no objection, Ms. Robinson?
Correct, no objection.
All right, Mr. Rathburn, the people have moved because of compliance issues to dismiss without prejudice today. That means that they could reissue at a later date, but for our purposes today, the case is dismissed. You're free to leave the Zoom courtroom, okay, sir?
All right, thank you.
Thank you, sir. That's all for the record docket 22022896.
Thank you, Your Honor. Next, the people would call Michael King, docket 22-03477.
All right. So we're on the record in docket 22-03477. That's people of the state of Michigan versus Michael King. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Ailish Gallagher on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Mr. King.
And sir, you are Michael King?
Yes, sir.
All right, you might want to stay in one place, Mr. King, all right?
Okay.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Gallagher, how are we proceeding?
Thank you, Your Honor. It's my understanding the defense is requesting a 30-day adjournment in order that Mr. King could get his license and comply.
That's correct.
For compliance. I'll make note that this is the first request at the first pretrial. So we'll reset for a second pretrial. March 14th at 9 a.m. All right, so Mr. King, your next date to get all your compliance issues resolved is March 14th at 9 a.m. Do you have that, sir?
Yes, sir.
Okay, March 14th at 9 a.m. Anything else for the record in docket 22-03477?
No, Your Honor, thank you.
Ms. Robinson?
No, Your Honor, thank you.
All right, that's all for the record in that file. Mr. King, you're free to leave the Zoom courtroom.
Oh, thank you.
People would call Tiara Orta, docket 22-02806.
Thank you.
Defendant is present and represented by Mr. Perron.
Who's the attorney again?
Jacob Perrone.
Mr. Perron. All right. So I'm calling to the record docket 22-02806. That's the people of the state of Michigan versus Tiara Orta. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Ailish Gallagher on behalf of the people.
Jacob Perrone on behalf of Tierra Orta.
And ma'am, you are Tiara Orta? Okay. This is the time set for a final pretrial in the matter. Ms. Gallagher, how are we proceeding?
Thank you, Your Honor. After talking and speaking with Mr. Perrone and reviewing deviation paperwork that had been sent over with a previous assistant prosecuting attorney, an offer had been extended, and we are going to enter into that offer today of an impaired. I don't know if it's Your Honor's preference to do an amended count 1 or an added count 3.
If this is a, let's see. So we have high BAC, let's do an added count 3.
Thank you, Your Honor. So people would move to add count 3 impaired MCL 257.6253-A, which is the 93 days and or $300 fine and or 360 hours of community service with rehabilitation programs under Michigan law, vehicle mobilization mandatory with a prior under Michigan law, with cost of prosecution and reimbursement for government for emergency response and expenses for prosecuting under MCL 769-1F.
All right. So Mr. Perrone, I'll restate that for the record. It's my understanding that we're going to add a count 3 of operating while impaired. With that, with a plea to that 93-day $300 fine under 257.625-A. With a plea to count 3, counts 1 and 2 are to be dismissed. And then there's other licensing sanctions for operating while impaired, being 360 hours of community service and immobilization, other things that probation can do in that regard. Does your client understand the ramifications of pleading guilty to count 3?
She does.
All right. May I inquire of your client of her advice of rights on that misdemeanor plea?
I have a sheet also.
Oh, perfect. Okay. So you have an advice of rights signed by your client?
Yes.
Thank you, Mr. Perrone. All right. So with that advice of rights, ma'am, this advice of rights indicating your trial rights and that you're waiving your trial rights today to plead to count 3. You've signed that. Is that true, ma'am? All right. So I'll only indicate 3 rights. You understand that, first of all, the penalty, the maximum penalty that the court could sentence you to is on a lesser, what operating while impaired is a 93-day and or $300. Do you understand that? And there are 3 main rights, along with the trial rights that you've indicated that the court will look at. You have a right to trial by jury, you have the right to counsel, and you have the right not to testify at trial. You understand those rights.
Yes.
You're willing to waive all those rights, including the rights and advice of right, and plead guilty today. I'm gonna have to. I know I don't have to raise your right hand. I'm gonna do it anyway. Okay. So raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. So I'm gonna bring your attention back to June 26th of 2022 at the offense location of North Pine in the city of Lansing. Were you on North Pine in the city of Lansing on June 26, 2022? And were you operating a motor vehicle on that time, at that time? And in the operation of that motor vehicle, were you operating a motor vehicle with the blood alcohol level of over 0.08 at the time? Anything towards the factual basis, Ms. Gallagher?
No, Your Honor.
Anything, Mr. Perone?
No, Your Honor.
All right, thank you. I find the factual basis to be knowing, voluntarily, and accurately made. I'm gonna refer this to probation. So, ma'am, I'm gonna refer this to probation. If you're here today, just go to the 5th floor and answer their questions. They'll set up a report. We're about 8 to 10 weeks out right now. So they'll prepare a report for me, and then we'll see what options are available to us at sentencing, okay? So I'm gonna refer to probation and we'll set a sentencing date for.
March 18th at 1:30.
Sentencing date will be March 18th at 1:30. Any questions concerning the plea or sentencing, Ms. Gallagher?
No, Your Honor, thank you.
Anything, Mr. Perone, concerning that date?
Yeah,
All right, I didn't check to see if that fit your schedule.
yeah.
Does that? Okay. Any other questions?
Nothing further.
All right, thank you. So I'll see you back here on March 18th at 1:30 with the report. Please refer to probation today, okay, ma'am? All right, thank you. That's all for the record in file 22-02-806. Thank you for your appearance today, Mr. Perone.
Thank you, Your Honor. The people would call Haley Thomas, docket 20-03028.
Ms. Thomas, that's Mr. Nagel's case.
It is, Your Honor.
Yes, Your Honor.
All right, we're on the record in docket 20-03028. That's people of the state of Michigan versus Haley L. Thomas. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Ailish Gallagher on behalf of the people.
Matt Nagel on behalf of Ms. Thomas, both of us appearing over Zoom, Your Honor.
All right, ma'am, and you are Haley Thomas?
Yes, Your Honor.
Okay, and you can hear me all right, Ms. Thomas?
Yes, I can.
All right, this is the time set for a pretrial in the matter. Ms. Gallagher, how are we proceeding?
Thank you, Your Honor. After speaking to defense counsel, I believe it's the people and defense's request to set this out for a second pretrial. There were just a couple issues that needed to be looked into. One was that in the UD-10, it indicated that the car may have had minor damage, so I did want a chance to reach out for restitution purposes. But further, it does appear that the defendant had gotten an OWI charge June 12th and had pled July 29th, and this was actually June 19th. And Mr. Nagel also represented that after that, on August 3rd, there was another OWI that resulted in an impaired plea, but I think that might be out of the city attorney's office, Your Honor.
All right.
And I was not able to locate it on SOS. So he's going to do due diligence to send that to me and any programming that the defendant had completed. And I am going to look into restitution, and we will try to find an amicable resolution after that.
All right, perfect. Mr. Nagel, is that your understanding of what came out of conversations with the DFA?
That's accurate, Your Honor.
All right. We're going to set it for second pretrial for discovery purposes. Probably a little more than 2 weeks, I would think.
Yeah, maybe 4 weeks.
Maybe 4. depending on both sides getting what they need. Second.
March 14th at night.
March 14th at 9 a.m. So March 14th at 9 a.m. is the second pretrial date for discovery purposes for both sides. Do you have that date, Mr. Nagel?
I do, Your Honor. That's good for me.
Miss Thomas, please keep in contact with your attorney, Matt Nagel, in regards to any further proceedings. It's reset for March 14th at 9 a.m. Anything else for the record in docket 20-33028, Ms. Gallagher?
Nothing for the people, Your Honor.
Anything, Mr. Nagel?
Nothing for the defense, Your Honor. Thank you very much.
All right, thank you. You're free to leave the Zoom courtroom. We'll see you in March, ma'am.
Thank you, Your Honor.
Twenty-two 3084, 22-3085, 22-3086.
All right. So we're on the record in docket 22-03084, 85, and 86. As indicated, will the parties please introduce themselves for the record?
Thank you, Your Honor. Elish Gallagher on behalf of the people.
Erin Robinson, Assistant Public Defender for Ms. Alleman.
All right. And ma'am, you are Jennifer Alleman?
Yes, sir.
All right. And you can hear me all right, ma'am?
Yes, sir.
All right. This is the time set for 3 files on an unlicensed, on 3 different files on unlicensed dog. Pre-trial, Ms. Gallagher, how are we proceeding today?
Thank you, Your Honor. At 9:06 a.m., Ms. Sutter did send me 4 attachments that appear to be the compliance of the dog license that were in these 3 files. So the people, because of that compliance, would move to dismiss.
All right, and I think these are all written on tickets, I believe.
Yes, it looks like they're separate.
Yeah, I think they're 3 separate, 3 tickets. So people move to dismiss
We have no objection.
for compliance.
Yeah, so I'm now ready with Mr. David George, ready with Gerald Wozniak. That is the most destruction of properties up for 9:30.
All right, Ms. Alleman, the three files, 3084, 85, and 86 have been dismissed for compliance purposes and proof of compliance. Understand they're dismissed without prejudice, so the people could move to reissue if they choose, but for our purposes today, the cases, all 3 are dismissed. Do you understand that, ma'am?
Yes, sir.
All right. Anything else for the record in docket 22-03084, 85, and 86? Ms. Gallagher?
None from the people, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, you're free to leave the Zoom courtroom, Ms. Alleman. Thank you for your appearance today.
Your Honor, the people are ready in David George, docket 22-01892.
So on the record in docket, is that the person who's in the?
Oh, no, he's in the breakout room with me right now.
All right, let's move him.
What are we doing? Okay.
Might have to close that. I don't know how you do that.
I just hit it.
Gerald
Yeah,
Wozniak.
to move, all right.
Yeah.
I'm assuming he got his fingerprints.
He is not.
All right. So
I'll
Ms.
send
Sutter,
it out to county again.
all right.
This is for Mr. George you're talking about?
Yeah,
He's in custody right now, so
So-
he can't take himself anywhere to do anything.
right. So they,
I'll email
you know,
county again.
yeah,
Like,
he's gonna be,
Your
he's gonna have
fingerprints
trouble
now.
with that. being
Yeah,
in
so
custody.
like, they know where he is if they want his fingerprints. He can't take himself anywhere.
All right, so we're on the record docket 22-01892. That is the people of the state of Michigan versus David George. For the parties, please introduce themselves for the record.
Thank you, Your Honor. Alicia Gallagher on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. George, who joins us via Zoom.
Sir, you are David George,
Yes, sir.
and you can hear me all right, Mr. George?
Yes, I can.
All right, this is the time set for a pretrial in the matter. Ms. Gallagher, how are we proceeding?
It's my understanding that Ms. Sutter would like a final pretrial set.
Okay,
That's correct.
so we'll set a final pretrial and jury trial just along to coincide with that. The final pretrial is set for
March 7th at 8:30.
March 7th at 8:30, and the corresponding jury trial,
March 28th at 8.
March 28th at 8. So the final pretrial for our purposes, March 7th at 8:30. Anything else for the record, Ms. Gallagher, in 22-01892?
Nothing, Your Honor. Thank you.
Anything else, Ms. Sutter?
No, Your Honor, thank you.
All right, Mr. George, keep in contact with your attorney, Lauren Sutter. Your final pretrial date is set for March 7th at 8:30. All right, sir?
Yes, sir.
All right, you're all set. Thank you for your appearance today.
Thank you.
Thanks, Your Honor. Next, the people are ready in Harold Wozniak, which is docket 22-01856.
What's that?
He's still in 8:30.
I think she's still, I think she's still got to talk to the victim in that case.
I did talk to the one victim briefly, Your Honor, but I haven't talked to Ms. Sutter yet.
All right, that's
On
fine.
Wozniak?
Yeah.
Or-
No, on Alvarez.
Right, and yeah, if you have something, you're out.
All right, so let's go on Mr. Wozniak. And I've got another prints request on Wozniak.
Okay.
All right, so he's got to get his prints done. All right, so we're on the record in docket 22-01856. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Alicia Gallagher on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Wozniak, who is standing to my right.
And sir, you are Gerald Wozniak? All right, this is time set for a pretrial in the matter. Ms. Gallagher, how are we proceeding?
Your Honor, the people did extend an offer of attempt malicious destruction of a building with no upfront jail with restitution at $407.12 owed to Sparrow. It's my understanding that Ms. Sutter would request a final pretrial. The people will keep this offer open up until the final pretrial.
Okay, so the pending offer is attempted MDOP of a building.
Yes, malicious destruction, yes, attempt malicious destruction of a building, and they are
And no
giving that
upfront jail.
offer contingent upon restitution at
Okay,
407.
and the restitution is 407.
Yes, Your Honor, and 12 cents.
All right, and so at this time, we're gonna set it for final pretrial,
Yes.
March 7th at 8:30.
and that'll be set for March 7th at 8:30.
And then the jury trial, March 28th at 8.
And then the corresponding jury trial would be March 28th at 8.
Thank you, Your Honor.
Thank you, Ms. Gallagher. So, Mr. Wozniak, please keep in contact with your attorney, Lauren Sutter. We've set the final pretrial for March 7th at 8:30. There is a offer that is going to be extended towards the final pretrial date. And then the jury trial is set for March 28th at 8 o'clock. Anything else for the record, Ms. Sutter?
Your Honor, just does he need the order for fingerprints to go down to LPD, or can he just walk around with them and do that?
Nathaniel, I'll hand it to him.
Yeah, Nathaniel handed to him. It's in the file, so you
Okay.
probably need it, but we'll give it to him.
Thank you.
Uh,
I have nothing further.
All right, thank you. That's all for the record docket 22-01856. And we'll provide you a copy of the order to take down so you can get your fingerprints.
Thank you.
That's all for the record in that file.
Thank you, Your Honor. Your Honor, Cyrus McKentry, it's up for review.
Correct, on McKin Street?
McKentry,
Yeah, McKintry.
I wasn't sure.
All right.
I think for a global report, maybe it's pending, but I didn't.
What's your name, ma'am?
Okay, one second, I'll be right with you. Okay.
Yeah, he's gonna give you work too.
That's the 30 days in Bingham County Jail.
More?
Was it for restitution? You wrote something in there.
He's on Zoom right now. I need to talk to him.
I don't know what you wrote.
Restitution hearing, fines and costs determined at restitution hearing.
Okay.
Oh, you supposed to sign the proof of service.
So McKentry was set in order to determine restitution on the matter from Miss Housefield, and Miss Housefield was supposed to contact our office if there was any restitution issues.
Okay,
Yeah, I didn't know that it was set. I thought we didn't set it and then we were gonna set it after 30 days.
If we were renew if in a week for complaining victim input, if any. Housefield to contact office. I don't know that we were ever contacted by this Housefield.
Okay.
So why did we set this for restitution here?
Because that's what the previous prosecutor asked. That there was restitution passively, because we did an
If it-
immediate sentence instead of sending it to probation.
Yeah, in a week,
And I believe Mr. Wiss,
it was Miss Housefield.
Ms. Housefield, thank you, thought she was going to check to see if there's any restitution. So while he was still in custody, we set the restitution.
And then we never heard from her.
And then we didn't hear anything. So I don't believe, I don't know the answer if there's restitution or not.
All right. Oh, yeah. See what you, let's put that one on hold for now.
Sorry, I just wasn't sure what review meant, so I was just trying
Yes.
to clarify.
Evidently means restitution hearing.
Okay.
Well, I thought I put a restitution here, but clearly I put it as a review.
I'll go talk to more. I was able to find in Miss Housefield's disposition note,
Okay.
it says no restitution.
All right. So just fines and costs. I can do fines and costs today. All right.
I think he would just be able to leave that and come back,
Right.
because I believe he has matters pending.
I believe that's true. All right, so let's go ahead and call that case. So we're on the record docket 22-02746. That's people of the state of Michigan versus Cyrus McKentry. For the parties, please introduce themselves for the record.
Thank you, Your Honor. Eilish Gallagher on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. McKentry.
And sir, you are Cyrus McKentry?
Yes, sir.
All right. This is the time set for restitution hearing. It's my understanding, Ms. Gallagher, that we've been contacted, or at least did some investigation on the file to understand that restitution is not needed in the file. And so the court can just go to fines and costs today.
Yes, Your Honor, it appears that Ms. Housefield did speak to the victim, and per Ms. Housefield's notes in our file that he said there was no restitution.
All right. And so with that, I'm going to waive fines and costs on the matter. I can't waive the $75 crime victims' rights fee, and I can't waive the $25 state fee, but that'll be $125. And since my understanding is Mr. McKentry has other files pending, I'm going to administratively close that today. Anything else for the record on docket 22-02746, Miss Gallagher?
And from the people, thank you, Your Honor.
Anything, Miss Robinson?
No, Your Honor, thank you.
All right, so Mr. McKentry, I did order $125 fines and costs, although I administratively closed the file. So you should be all set today, all right, sir?
So I'll be able to get out today?
No, you'll get out after your 30 days.
Yeah, you've still got to serve your sentence.
And I got to pay $125.
But that's been administratively closed, so you don't have to worry about that.
Until I get out, right?
You don't have to, that's been closed, so you don't have to worry about that at all. You just have to finish the sentence, your 30-day sentence.
All right, and I won't be on probation no more?
No, you're not on probation.
All right, thank you.
You're welcome. That's all for the record docket 22-02-746. You're free to leave the Zoom courtroom. Thank you for your appearance today.
All right, thank you.
He's ready right now. There's more here, so I'm gonna go talk to him.
It's 7 days credit, right?
And I think that's all we're ready on.
All
at
right.
the moment. I'm sorry about that.
No, you're all set. That was plenty. Did you need?
Yeah, I mean, I briefly, it's just, I think it maybe has,
He said he lost
disconnected.
Wi-Fi.
Something,
Yeah.
It seemed like it was abrupt, but it wasn't abrupt in like a bad way. It
No.
was just
Yeah.
abrupt.
He came right on board again. So if you want to talk to him, we can throw you in a breakout.
Oh, I can go. I'm sorry, Aaron. I didn't realize he was back on.
Let's shut this off.
We're on the record in docket 22-03248 and 22-03250. People of the state of Michigan versus Mark A. Mitchell. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Alish Gallagher on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Mitchell.
And where's Mr.
Frank
Mitchell?
Raffy.
He's not here.
Okay. This was scheduled for 9:30. It is now 10:01. It appears the defendants failed to appear for the pretrial. Okay. Ms. Gallagher, how would you like to proceed?
Your Honor, I leave it to the court's discretion in terms of if the court would like to prepare a bench warrant on these two files for the failure to appear today.
All right, Ms. Robinson.
I'll leave it to the court's discretion as well.
All right, these are both retail frauds, if I'm correct.
Correct.
All right, I have a previous fail to appear at arraignment, but I don't put a lot of stock in I don't know if they always get the notice. So I'm gonna do a defendant fail to appear bench warrant bond forfeiture with a 48-hour hold.
Okay. Did you want to call Deshaun Alexander? That's not working.
No.
Sorry. It's hard to tell.
It's okay.
All right, we're currently in the court session. I just want to see who else is here. Would the person on the cell phone please identify themselves?
Frank Raffy.
How do you
you hear
spell
me?
your last name, sir?
Oh, R-A-P-P-E, Frank Chester Raffy.
And what time is your hearing set for today?
It was set for February 14th at 9:30 a.m. I couldn't get the Zoom to work, so I tried the telephone.
Do you have a case number?
Case number. Yes, I do. It's
What number is that?
It's 22L27673771. Then there's some OI at the end. I have a reference number.
Oh, is it arraignment for?
It's an informal hearing.
All right, so Mr. Rappy, I
Yeah.
think you're supposed to be in front of Magistrate Millmore, not in front of the court. Let me give you what's her Zoom?
Is it?
Because I don't have you in my docket, but let me make sure you've got her.
Oh, I have two numbers here where it says please call. I called the first number. Then it says or call 9. Would that be the number I need?
You need 646-876. Does he need the meeting ID or the call number?
The call.
So you need 646-876-9923 or 669-900-6833.
He also needs the meeting.
Okay, I'm on the 8769923 number right now. So maybe
Okay,
I
then
try
you
the other
should-
number.
No, that's fine. Then you should enter her meeting number. Her meeting ID is 216-101-7816.
Meeting number. Oh, I don't know where that is. Is it on this white paper they sent me?
I'm not sure what they sent you.
Well,
Take
it's a
down the
notice
other
of
number.
appearance.
Yeah, so take down the other number, 669-900-6833. You want to take down that
Yeah,
other call number, and then her meeting ID number is 216-101-7816.
Oh boy, I gotta go there. Oh, right there. Oh, I gotta get to a pencil. A pen. Okay. Could you read her meeting number again one more time, please?
Sure. Her meeting number is 216-101-7.
You're going fast. I'm 72 years old. I can write very slow. Sorry, Your Honor. I'm very sorry. 216
101
101
7816.
7816.
And then
Okay.
here's another call number. She's got two call numbers, and I'll give you the second one. The second
Okay.
call number is 669
669
900
900
6833.
6833. Thank you very much for being so kind and understanding.
Okay. Well, as long as you get to the right courtroom, we want to make sure you're in the right courtroom. All right, sir?
Yeah, I've been waiting on the phone for almost a half hour. Not that,
All right,
I'm trying to do the right thing here,
Right. Let's get you the right courtroom. So go over to Magistrate Millmore. You should be all set.
All right. Thank you very much.
You're welcome. And then
Bye.
Mr.
Yes.
Jan M. Is that Jan Milikoff?
Yeah, Jan Milikoff.
All right. You're in the right place, Mr. Milikoff. I just have some cases to call before you, okay?
Okay.
God dang it, Hank. Oh.
All right, Miss Miles, I've got you in the courtroom. just stand by. You're in the right place, and we'll call your case in a second, all right?
Yeah, for sure.
All right. So we're on the record in docket 22-00744, people of the state of Michigan versus Deshaun Alexander. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Elish Gallagher on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Alexander, who joins us from the ICJ tablet on Zoom.
And sir, you are Deshaun Alexander?
Yes.
And you can hear me all right, Mr. Alexander?
Yes.
All right, this is the time set for a pretrial. Ms. Gallagher, how are we proceeding today?
Thank you, Your Honor. I did have a chance to confirm that Mr. Alexander would not qualify for 76820 in terms, I'm sorry, 769, because he has a prior conviction for a felonious assault. It's my understanding he would like to set it for a final pretrial and a jury trial.
Okay.
That's correct.
So we'll set for final pretrial on March 7th at 8:30. And jury trial?
March 28th at 8.
March 28th at 8. So, Mr. Alexander, we've set your final pretrial for March 7th at 8:30. Jury trial set for March 28th at 8 o'clock. Please keep in contact with your attorney, Lauren Sutter, if you have any questions. Anything else in regard to 22-00744, Ms. Gallagher?
Nothing from the people, thank you.
Anything, Ms. Sutter?
Nothing, Your Honor. Thank you.
All right, Mr. Alexander, you're all set. You're free to leave the Zoom courtroom.
I believe Bradley Sheehan.
I haven't seen him hop back on. Noah Alvarez is though.
Okay.
I've emailed him telling him to log back in. call to. If we get to it.
Could I go pop back into that breakout? I'm
Sure,
really
talk
fast here.
to the victim.
Thank you.
Is that Thomason?
Yeah.
Yeah.
All right, so Mr. Thomason, we're going to put you in a breakout room with the assistant prosecutor, all right? Mr. Thomason, you probably need to unmute yourself.
Am I done?
You're all set, sir. In the Ingham County Jail, you're all set.
Okay. And what was those dates again?
March 7th is your final pretrial date.
Alright. March 7th at what time?
8:30.
Alright.
Gabriel Thomason.
Gabriel.
Thomason?
Oh, Gabrielle. Okay, let's say there's,
I just have.
that's the correct person.
Okay. Gabrielle Thomason.
Yes, that's the correct person.
Okay, Gabrielle Thomason, are you there?
This is Isaiah Thompson now.
Okay, all right, Isaiah Thomason, I'm gonna put you in a breakout room with the assistant prosecutor, Miss Gallagher, all right?
Yes, sir.
All right, so I'm gonna have Miss Gallagher and Mr. Thomason placed in a breakout room. All right, so Mr. Shaler, you're on the Joy Tab phone.
Yes, I am. Your
All
Honor.
right. All right, I got your public defender here. We'll call your case in just a minute. All right, sir?
Thank you, Your Honor.
You're welcome. Miss Miles? Jada Miles? You can unmute.
Hi, sorry.
All right, no, that's all right. This was set for show cause for fail to make payments, is my understanding. And then I just looked in the computer, or I had my assistant look in the computer, and it appears that you've made payments in this case. Is that correct?
Yes, Your Honor. And actually, I was calling to keep them updated. I've been working in the Detroit area. Some days they have me in Plymouth, some days they have me in Livonia, some Brighton. And I just started that job and it's an automotive, so it's 7. I leave the house at like 6 a.m. maybe, and don't get home till 9. So when I started that job, I started a week after actually sentencing, I think it was,
Right.
when you set up my payment plans and everything. And I went to go use my debit card. I promise I'll make this short. I went to go use my debit card out in Livonia. I have Huntington. Well, yes, I'm so grateful for Huntington being very overprotective. And basically, they locked my card out and they're like, oh, we're going to send you a new card. I was like, no, I assure you that was me. And they insisted. And so it took literally 21 days for them to get me my new debit card. So I was late on making that payment. I didn't have the luxury or the ability to tell my job, hey, look, I gotta go make these payments. That would require me to take the whole day off of work almost. And so I just, made it when
So
I could.
are you still on that same plan, that December, January, February, March plan?
I believe I have it fully paid off.
Okay. All right. I've got you owing 137.48 left. So
Yeah.
you want to check that.
Yeah.
But as far as the show cause, I'll dismiss the show cause. Just keep your payments up. Make sure that if it's not paid off, it's paid off soon, and you should be all set.
Is that what a show cause would be? It'd be if I wasn't making the payments.
Correct. What they would do is they would come and tell me to show cause you. I would show cause you rather than bench warrant you right off the bat for you to explain, and maybe we could set something up that's working.
Right.
I have some question whether this really needed to be show cause if you were making payments, but just make sure that it's paid off so we don't start the whole cycle over again.
Yeah, no, I actually checked it while I was waiting for my turn, and I paid $137 plus a $5 fee. It's all been paid.
Okay.
So what happens next
Right now.
once everything's paid?
All right, so you should be all set, Miss Miles. That should be the end of your payments. I've dismissed the show cause, so you should be all set. All right.
Do I receive something in the mail from you, or do I have to come in for another hearing?
You probably don't receive anything from the court. You could get confirmation that you've made your payments, but that's probably going to be verbally. I don't know if they're going to send you anything.
Okay, yeah, I got the email
Right.
confirmation confirming my payment amount, but
Perfect. Just keep that so you have that. All right.
all right, thank you.
All right, you're all set. So that's all for the record docket 22-02499. Miss Miles, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you. Have a good day.
You too. So we have Alvarez, Shaler, Milikoff, English, and Lavoy,
We're ready in English.
and Mitchell.
No, we handled Mitchell.
What, I'm sorry?
Mark Mitchell, right?
No,
Oh, no, there's
Tyrese
Tyrese. Oh,
Mitchell.
sorry. Okay, my bad.
And then there's your Christopher.
My boy?
Yeah.
I don't think he's here.
We didn't do, we could do Heidi English too.
Yep, we're ready on that.
Okay. And then you said Melchikoff is not here.
He was, yeah, he's on Zoom.
Oh, okay.
He was on Zoom.
The
yeah.
boy isn't here.
I see. I know, I'm sorry. I heard you on that one. I just, is he represented?
Mr. Milikoff, I don't know.
Okay.
I don't think so.
Mr. Milikoff, are you represented today?
No, I don't believe so.
All right.
Got her.
All right, Mr. Milikoff, I'm going to place you in a breakout room with the assistant prosecutor so you can discuss some of these two files. All right.
All right. Thank you.
All right. So stand by when Miss Gallagher gets. We'll place you both in a breakout room. So stand by in about a minute or two.
All right.
All right, we're on the record in docket 22-01813 and 22-01814. People of the state of Michigan versus Jan Milikoff. Will the parties please introduce themselves for the record?
Thank you, Your Honor. English Gallagher on behalf of the people.
And sir, you are Jan Milikoff
Jan Lykoff.
of Lykoff. And you can hear me all right, Mr. Lykoff?
I can, yes.
All right, thank you. This is the time set for pre-trial, Ms. Gallagher. How are we proceeding today?
Thank you, Your Honor. I had an opportunity to view both of the dog licensings, and due to the compliance, the people are moving for dismissal.
Okay. So people move to dismiss without prejudice, compliance. All right, so Ms. Lykoff, Mr. Lykoff, The people are moving to dismiss both of these files today without prejudice, which means they could bring them back at a later date. That I don't think that'll be the case here. For our purposes, the cases are dismissed due to compliance purposes. So you should be all set. All right, Mr. Lykoff?
All right, perfect. Thank you, Your Honor.
All right. Anything else for the record, docket 2201-814 or 13?
And from the people, Your Honor.
All right. You should be all set. Thank you for your appearance today. You can leave the Zoom courtroom, Mr. Lykoff.
All right, thank you.
The people would call Bradley Shaler, Your Honor, 22-3581.
So we're on the record in docket 2203-581. People of the state of Michigan versus Bradley Shaler. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Ailish Gallagher on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Shaler, who joins us via Zoom.
And Mr. Shaler, you can unmute yourself at this time. You should unmute yourself on it's *6 on a phone. It should come up as a microphone on if you're anything other than a phone.
How's
There you
that?
go.
Good.
All right. Sir, you are Bradley Shaler?
Yes, sir, I am.
All right. This is the time set for a pre-trial. Ms. Gallagher, how are we proceeding?
Your Honor, I had extended the same offer that the prior assistant prosecuting attorney had extended. The offer would be to plead guilty to count 2, dog at large, with an agreement of a delayed sentence under MCL 771.1, with the condition that the defendant would pay restitution for time and tranquilizers, and it's noted at 92.95.
All right. And Ms. Sutter, how are we proceeding today?
Your Honor, that is my understanding of the offer, and that the other related charges will be dismissed, and Mr. Shaler intends to accept that offer today.
All right. So let's go make sure I go through the offer again. The offer is to plead to count 3.
Count 2, dog at large.
Okay. Plead to count 2. Dog at large. And then the other parts of the offer, Ms. Gallagher.
Would be to dismiss counts 1 and 3
Okay.
with an agreement of a delayed sentence under 771.1, with condition that he pay restitution. It says for time and tranquilizers at 92.95.
92.95.
Right, Your Honor.
Do you have any idea how long you want so we would revisit this? I'm not going to put it on probation or anything.
Right.
We just set it for a sentencing date out. What are you thinking, Ms. Sutter?
So if the only condition is to pay the 92.95 and have the charge be dismissed,
Right.
Mr. Shaler has advised me he thinks he can have it paid by March 11th. So I think 2 to 3 months max would be sufficient just to
All
get
right.
beyond that payment.
So he thinks he can pay the entire thing by March 11th.
That is what he has advised me.
And then you're thinking more time after that?
I'm thinking whatever the next state day is after that would be sufficient.
All right. So that'd be like March 13th.
I think that would be,
All right.
that'd be okay with the defense.
Yeah. All right. So Mr. Shaler, that's your understanding of the plea agreement. I'll restate it. You're going to plead guilty to count 2, which is a dog at large, with a plea to count 2. Counts 1 and 3 are to be dismissed. We're going to defer the sentencing date on this matter to March 13th in order for you to pay restitution. What's that?
March 14th.
Is that the date of the
Stat day would be March 14th.
stat? So to be March 14th would be the date of sentencing for you to pay the restitution of $92.95. I think there's crime victims' rights of 75 and a state of 25, and then whatever fines and costs are made a part of that.
Your Honor, if that's how my understanding of 771, so there's an opportunity to pay restitution or whatever is agreed, and then the charge would be dismissed. If you were to fail to do it, then the full sentence would
All right.
apply, including crime victims' rights state costs.
Perfect. So with that understanding, the $92.95 would be paid by March 14th, and the case would be dismissed. Is that your understanding, Mr. Shaler?
Yes, Your Honor, it is.
All right. So I don't forget. So Ms. Sutter, may I inquire your client of their advice of rights to the misdemeanor plea?
Yes.
So you understand that we've talked about negotiations. If I was not to follow the negotiations, but the ultimate penalty for dog at large is 90 days and or $500. Do you understand that, sir?
Yes, Your Honor.
All right. That's the ultimate penalty. We've talked about a deferred sentence being part of negotiations. And so that the court's going to follow that recommendation. But I do want you to understand that the ultimate penalty is 90 days and or $500. Do you understand that?
Yes, Your Honor.
All right. If you please accept it, you will not have a trial of any kind in this misdemeanor case. So I'll run through those rights for you. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question those witnesses against you. You, of course, are represented by Public Defender Lauren Sutter. She would cross-examine and contest any charges brought against you in trial. You have the right to have the court order any witnesses in your defense. You have the right to remain silent, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand your trial rights in this case?
Yes, Your Honor.
If you're pleased accepted, you'll give up the claim that any of this was brought by threats or duress, other than the plea agreement that we've already discussed, and that any of your trial rights will be waived because you're not having a trial today. You're pleading guilty today. Is it your intent to waive your rights to trial and to plead guilty today, sir?
Yes, Your Honor.
And raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Okay, I'm going to bring your attention back to December 6th of 2021 at the offense location of Lockbridge in the city of Lansing. Were you in charge of or in control of or responsible for a pit bull named Maestro on that date at that time in the city of Lansing?
Yes, Your Honor.
And was Maestro running loose on that day in violation of the ordinance adopted by the Ingham County Board of Commissioners?
He was, Your Honor.
All right. Anything in regards to the factual basis, Ms. Gallagher?
No, Your Honor, thank you.
Anything, Ms. Sutter?
No, Your Honor.
I find the factual basis to be understanding, voluntarily, and accurately made. So I'll accept the plea. We will set this for May 14th. I'm sorry. Did I say
March.
May? Yeah, let's not do that. March 14th, 2023. At what time? At 9 o'clock. And that'll be the date that the 92.95 should be paid before that date. And if it's paid before that date, then the case will be dismissed pursuant to the plea agreement. Is that your understanding, Mr. Shaler?
Yes, it is.
All right. Anything else for the record in docket 2203-581, Ms. Gallagher?
No, Your Honor, thank you.
Anything, Ms. Sutter?
No, Your Honor, thank you.
All right, you're all set, Mr. Shaler. We'll see you back on March 14th, 2023, or from your attorney, if your attorney indicates that there's no reason to have the hearing, all right?
Thank you, everyone.
All right, thank you. You're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
That's
Good day.
incorrect, but all counts for Superior Court cases. That's not like accurate in terms of they're not like
Oh,
confirmation.
who's he paying restitution to?
Animal control.
Animal control. As long as he knows that, I wasn't sure.
Well, he pays it to this court here. and it
Okay,
gets-
all right.
We just have to put it in
All
the
right,
computer, so I have to have some.
Right,
So
so we pay
animal
to the
control.
collections when it gets forwarded.
Probably the most important question. Who does he pay to? Because I wasn't sure.
Yeah, they always ultimately pay to the court.
Right,
The court
and
is
then we send it
responsible.
out.
Yeah.
What's the next one?
Thank you, Your Honor. I believe that we already, well, Flores is not here, so I'm gonna
No,
call
yes.
Heidi English, which is, I believe, 22-2952-51-53-54-55-56-57-58-59.
All right. So we're on the record in dockets 5-2 through 5-9. That is people of the state of Michigan versus Heidi English. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Elish Gallagher on behalf of the people.
Gary Robinson, Assistant Public Defender on behalf of Ms. English.
All right. And this is the time set for a plea in this matter. I have it as plea/pre-trial. Ms. Gallagher, how are we proceeding today?
It's my understanding, Your Honor, that the defendant wishes to enter a plea into one count of the dog license and Then it would be under 771.1 with the defendant conditionally showing and paying for updated 5-dog license. I'll defer to Ms. Robertson if I'm incorrect.
All right.
Yeah.
What file does she intend to plead?
I
on?
believe it is going to be on 2951.
5-1.
That's
Okay.
okay. Yes.
All right. And so, Ms. Gallagher, Ms. Robinson, what is the extent of the plea offer, to your understanding?
Yes, Your Honor, she'll be pleading to the 2951 file today with an agreement that it would be a deferral under 771.1 with a term that she must get all 5 animals licensed within 6 months. After 6 months, if all 5 animals that are still in the home are licensed, the case would ultimately get dismissed. If not, the conviction would enter.
All right. So 6 animals licensed.
5.
5.
There's 5 total.
All right. 5 animals licensed. And that's a 6-month date. So you do the calendar work on that. Sometime in August, huh?
Yeah. August 15th at 9.
All right. So I'll indicate my understanding. This is a plea to this file, which is 5-1. With a plea to this file, all other files dismissed.
Thank you, Your Honor, yes.
And then we'll defer sentence under 771.1, deferral for 6 months to August 15th at 9 a.m. By that time, all 5 other animals will be licensed. If they're not licensed, then the plea will be taken and this will be treated as a misdemeanor conviction.
Correct.
All right. Ms. English, is that your understanding of the plea offer?
Yes, Your
All
Honor.
right. And you intend to accept that offer today?
Yes.
All right. So may I inquire of your client of their advice of rights, Ms. Robbins?
You may.
All right. So in this misdemeanor plea, the ultimate penalty for unlicensed dog that you're pleading to under this file is 90 days and or $300, I believe. Is it $300?
I'm just gonna check.
I think it was the last one of the last. What's the fines and costs? 93 days. The other file had it.
The other one was 300.
Yeah. So the ultimate penalty in this is 90 days and or $300 under the state statute, which is a county ordinance. Do you understand that's the ultimate penalty you could pay?
Yes, sir.
All right. You understand that if we don't have a trial today, you'll be waiving these trial rights, and I'll walk you through them, okay? You have the right to be tried by a jury. You have the right to be presumed innocent till proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses. You, of course, are represented by Public Defender Erin Robinson. She would contest any charges, cross-examining any witnesses brought against you. You have the right to have the court order any witnesses the defendant you may have for your defense. You have the right to remain silent, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand the nature of your trial rights today, ma'am?
Yes.
If the plea is accepted, you'll give up the claim that the result of the plea was because of threat or duress. We've talked about the plea agreement. So other than the plea agreement, this is all done because you're pleading guilty today because you choose to plead guilty today. Is that correct? All right. And you, of course, be giving up the right to appeal any conviction, because any conviction would be based on plea, not a trial. You understand that? All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm going to bring your attention back on this file to it looks like October 24th of 2022 at the offense location in the city of Lansing Avenue. Were you in charge or in control or responsible for, is it Freja or Freja? Freja, it's a brindle, all right. And was that dog unlicensed on that day? All right. With that understanding, anything towards a factual basis, Ms. Gallagher?
And Your Honor, thank you.
Anything, Ms. Robinson?
No, Your Honor, thanks.
Your plea is accepted as understanding, voluntarily and accurately made. I will defer sentencing as to 771.1 for 6 months. So sentencing date will be for August 15th at 9 a.m. You understand the nature of that is so that all other 5 animals are licensed. Once you show Miss Robinson that, or you make it apparent that that is, there may be no need for the hearing, okay? And so they'll let us know, but you have till August 15th to get that done. I would get that done as soon as possible.
Yep.
Okay. Anything else for the record in 2202951, Ms. Gallagher? Anything, Ms. Robinson?
No, Your Honor, thanks.
Okay, you're all set. Thank you for your appearance today.
Thank you, Your Honor. The people call Noah Alvarez and file 22-888.
Right, so we're on the record in docket 2200888. I also have fingerprints, Ms. Sutter, on this one.
Yes, I understand. We did get permission for him to appear over Zoom last time, given his his placement right now in
Right.
a mental health facility.
All right, so if he's out, is he?
He's not out. He is still
Oh, he's still
in the facility. He's at Bridges right now.
All right. I don't see him.
He puts his head down. He's on the side there. Yeah.
All right, Mr. Alvarez. So we're on the record on 2200888. We still have outstanding fingerprints that we'll have to take care of. This is parties have introduced themselves. Have you introduced yourself?
No.
Parties introduce yourselves for the record.
Thank you, Your Honor. Elish Gallagher on behalf of the people.
Good afternoon, or good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Alvarez, who joins us via Zoom.
And sir, you can unmute yourself. Are you Noah Alvarez? I've got you lighting up, but I still don't hear you.
Mr. Alvarez, can you hear us?
I can kind of hear you now. All right, so you are Noah Alvarez?
Yes, sir.
All right, thank you. This is the time set for a final pretrial on the matter. Ms. Gallagher, how are we proceeding?
Thank you, Your Honor. It's my understanding that an offer has been extended, that the defendant could plead to count 1, domestic violence. We would dismiss upon successful plea and sentencing. Count 2, assault and battery. Pursuant to People versus Killebrew, victim rights would be on both files as originally charged, counts 1 and counts 2, and restitution on both counts originally charged. Specifically, Your Honor, $50 in gas money owed to Isaiah Thomason. There were 2, after speaking to him today, there were 2 times that he had to go to U of M Ann Arbor facility. He did indicate he has medical insurance. He said he had to get a plate put in his cheek, and his restitution would be the gas required to get there.
All right. Is that your understanding of the offer at this time, Ms. Sutter?
It is, Your Honor.
All right. And is Mr. Alvarez, so what is the intent? Is Mr. Alvarez going to plead guilty?
It is his intent to accept that offer
Oh,
today.
and I did forget to mention, Your Honor, he does not qualify for 7694.
Okay, does not qualify for 769. All right, I'll restate that for the record just to make sure. This is a plea to count 1, dismiss count 2. Crime victims' rights are available to both victims on both files. For sentencing purposes, there's a $50 restitution charge to Isaiah Thomas for transportation, and the Mr. Alvarez does not qualify for 769-4A.
Correct.
And it's Mr. Alvarez's intent to take that offer and to plead guilty today.
Yes, Your Honor, I believe that. And just for the record, the people also consent to Zoom.
Okay. So as long as there's consent to Zoom, Mr. Alvarez, I'll have to just see a portion of your face, and I'm also going to swear you in. You understand the maximum penalty in domestic assault that you're pleading to is 93 days and or $500. Do you understand that, sir? Oh, you've got to unmute yourself.
Yes, sir.
All right. If you plead guilty today, you'll be giving up the following trial rights, and I'll walk you through those rights. You have the right to be tried by jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witness against you appear at trial, to question those witnesses. You, of course, are represented by Public Defender Lauren Sutter. She would be present to cross-examine any witnesses and cross-examine and contest any charges brought against you. You have the right to have the court order any witnesses to appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you, and you have the right to testify at trial if you choose to testify. Do you understand your trial rights today, sir?
Yes, sir.
All right. If your plea is accepted, you'll give up the claim that the plea was a result of any promises or threats, that it was not your choice to plead guilty. We've talked about the Killebrew agreement. You'll also be giving up the rights to appeal. You won't be having a trial. You'll be pleading guilty. Is it your intent to waive your rights today and plead guilty to the charge?
Yes, sir.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to March 7th of 2022 on Waverly Road in the city of Lansing. Were you on Waverly Road in the city of Lansing on March 7th, 2022?
Yes, sir.
And in relation to the assault on Gabrielle Thomason, who is Gabrielle Thomason to you?
She's my ex.
Okay. And you were in a dating relationship with Miss Thomason?
Yes, sir.
All right. And if you could explain to me what you did with Miss Thomason to make you guilty of assault and battery in this case.
We got into a verbal argument and then it became physical.
Okay. Did you push or offensively make contact with Miss Thomason?
Yes, sir.
All right. And did you do so? And that was not done in self-defense. Is that correct?
No, sir.
All right. Anything in regards to the factual basis, Ms. Gallagher?
No, Your Honor, thank you.
Anything, Ms. Sutter?
No, Your Honor, thank you.
I find the factual basis to be understanding, voluntarily, and accurately made. I think we'll refer this to probation. How do we intend probation to contact Mr. Alvarez?
You know, if the court could permit it, he could call and set up an appointment with them. And he did advise me that if he needed to come in to do an in-person interview with them, he would be able to leave the facility to go do that. He could do his fingerprints at the same time.
All right. So should I live that how probation wants it? I'm not sure.
If he'd be permitted to make first contact with them through phone call in the next 48 hours to schedule an in-person appointment.
Let's do that. Okay. So I'm going to refer to probation. You're to call probation within the next 48 hours and explain to them that you've pled. Part of your sentencing is for you to contact them, and you're to contact them by our 48 hours for our purposes will be, let's make it Thursday by 5. Oh, that's right. So Thursday by noon.
Make the first phone call to probation.
Yeah. So make your first phone call. I would make it tomorrow to be safe, but by at least Thursday by noon. All right.
Yes, sir.
I'll get the number to you today to call.
Okay. And how long will I be on probation?
It should be, I don't know how long. They'll ask you questions. What they're going to do is prepare a report for me, and then we'll look at the options at sentencing. Sentencing date?
April 18th at 1:30.
April 18th at 1:30. I don't know how long the actual interview will take, but your sentencing date is April 18th at 1:30. Just provide them any information they request, how they request it. They'll put it in report, and then we'll have it ready for the for that April 18th date, all right?
Your Honor,
Yes.
just because we're the victims on Zoom right now, are they allowed to appear via Zoom for the sentencing date?
I don't have a, well, yeah, I don't,
I do think they might wish to speak as well.
yeah, but we want we're definitely gonna have victims at the sentencing date, right?
I believe so, Your Honor.
Yeah, and I don't have a problem with them coming by Zoom.
The victims.
Yeah, if it's more, the defendant has to be here in person.
Thank you, Your Honor.
But the victims, I'd like, whatever's easiest for them to get here.
Thank you, Your Honor.
Okay. Ms. Sutter, you have that April 18th date at 1:30?
I do.
And does Mr. Alvarez have a time frame for being at the facility right now?
I don't think he has a firm timeline.
All right.
It's more as how he's doing in the moment, moving forward with plans. He
All
just
right.
recently moved from Forest View to Bridges, so
Okay.
he's, I think, gonna be there for
All
a
right,
little while.
you let the court know if he's
Address
available on that
changes.
April 18th or the address change.
Will do, Your Honor.
All right, so Mr. Alvarez, the court will keep in contact with your attorney, Lauren Sutter. Right now, your date for sentencing is April 18th at 1:30. All right, sir?
Yes, sir.
All right. Anything else for the record, docket 22-00888, Ms. Gallagher?
May I tender the restitution form to Your Honor?
Yes, please.
Thank you.
Anything else, Ms. Sutter?
Nothing further, thank you.
All right. That's all for the record for that file. You're all set, Mr. Alvarez, okay?
Okay, thank you. All right.
Christopher Lavoie?
Yeah, I also have Tyrese.
Oh, Pierce is fingerprints.
Okay,
10 a.m.
got it. Did we do Lavoie? Was that yours or no?
He just.
No,
got here, so
he's
there.
here.
Oh,
We're
okay,
gonna
so we'll
reset it for
call-
30 days for compliance, but we're ready on
Did you want
it.
to call Ty? Which one do you guys want?
So we'll do
Either
Lavoie.
already.
Lavoie, yes, Your Honor. Christopher Lavoie on 22-236869-3409.
3409. All right, we'll call to the record docket 22-02368-69 and 3409. That's people of the state of Michigan versus Christopher Lavoie. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Ailish Gallagher on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Lavoie.
And you are Christopher Lavoie?
Yes, sir.
All right. This is the time set for a pretrial on this matter, on these three matters. Ms. Gallagher, how are we proceeding today?
Thank you, Your Honor. It's my understanding the defense is requesting an adjournment in order for the defendant to comply and get the dog license.
All right. Is that your understanding, Ms. Robinson?
It is.
All right. So request for a second pretrial. For adjournment, for compliance purposes. Let's go out 4 weeks.
March 14th.
Okay, so March 14th at 9 a.m. So, Mr. Lavoie, we've set this for March 14th at 2020, March 14th at 9 a.m. in order for you to get any compliance purposes you need necessary for that date. That's on all three files. Anything else for the record in docket 2368 or 2369 or 409? Ms. Gallagher?
None from the people, Your Honor.
All right, Ms. Robinson?
No, Your Honor, thank you.
All right, we'll see you on March 14th. You're all set, sir.
All right, thank you. You have a good day.
You too.
Your Honor, just as a matter of,
Yeah, we'll give you the hearing and we'll give you the notice. And Ms. Gallagher.
just as a housekeeping matter, I believe the victims and the case are still on the Zoom. If we could just let them know that they watched
Oh.
the plea, but I don't know if they know they're free to
All
exit.
right. So they're the victims on the Alvarez case, right?
Correct.
Okay. Victims on the Alvarez case, you're free to leave the Zoom courtroom if you choose.
Okay, thank you.
All right, thank you.
Thank you, Your Honor. And then people call Tyrese Mitchell, docket 223336.
All right. Those three for Lavoy. Okay, and we're on the record in docket 22-03336. People of the state of Michigan versus Tyrese L. Mitchell. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Alicia Gallagher on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Mitchell.
All right, this is the time set for a motion hearing. This is on the defendant's motion to reduce bond. Ms. Sutter?
Yes, Your Honor, to amend bond.
Amend
Specifically, there is currently a condition of bond along with a no contact order that Mr. Mitchell is to be on a GPS tether. He has had some conversations with me where he is becoming concerned about the financial burden of this GPS tether. Specifically, he's concerned he's trying to figure out how to pay rent and electric along with his GPS tether. I have confirmed with JSG as well as the oversight with probation that he has had no allegations of violations while on the GPS tether. He has already pled in this case. He has completed his PSI and he is merely waiting sentencing at the end of April. So he's got quite a bit of time to just be on tether with nothing, no court hearings, no court appearances or anything. In the meantime, while he's still paying for the GPS tether. So it's my request today that that specific condition of bond be removed. Understanding that no contact order was absolutely stay in place. All other conditions of bond, merely the removal of the GPS tether.
Okay, because since April
4th, it looks like.
April 4th. Ms. Gallagher, any response?
Thank you, Your Honor. I did reach out to JSG personally, and I did hear back that there were no compliance issues at this point. I have no way to verify any of the information regarding the hardship. I don't know if pretrial service did that or if that is something that they do as a matter of course. I leave it in the court's discretion, understanding that you know, the conduct of the defendant is what got us here. So there may be some hardships.
And I will indicate for the record that there's currently a no contact order.
Yes.
With Jasmine Smith. And he is still under sentence. I mean, I'm still set to see him April 4th.
Yes.
At 2023. So he certainly doesn't want anything reported about Ms. Smith coming to the court's attention before sentencing. This is a first offense, charged as domestic violence first offense. So I think it is reasonable to request that the GPS not be a part of the finances situation after he's pled and awaiting sentencing, understanding that that they're probably in the midst of talking to Ms. Smith right now, you know, in preparation for the April 4th. So I will grant the motion to amend bond.
Thank you, Your Honor.
Thank you, Your Honor.
To amend bond and to strike the GPS with the understanding that there's a continued no contact with Jasmine Smith.
Yes.
Anything else for the record in docket 22-00336, Ms. Gallagher?
None, thank you, Your Honor.
Anything, Ms. Sutter?
Other than Your Honor, just a quick response in terms of the financial hardship, he qualifies for our office.
Okay,
So
right, that tells me what he needs.
Yes.
All right, so with that understanding, that's all for that file on Mr. Mitchell.
Yes, thank you.
I have to finish Miss English writing in Miss English's files.
Yeah.
But Ms. Gallagher, thank you for covering today.
Of course, it's a pleasure. Thank you, Your
Yeah.
Honor.
Will you be here this afternoon, Ms. Gallagher?
So fun fact, I was just looking at that. So I do see that there is a sentencing.
There's a sentencing for Mr. Powers.
Is there anything else that the court wishes to have a prosecutor present for besides obviously the Stevon Jackson that's up for 2 p.m.?
Yeah, I don't know what the OSCE is a review.
I'm looking at.
So let's look at that.
Okay.
This is something that the probation officer did because they're in custody. Is this the one that they've requested resentencing on?
I don't know.
Thank you. Do I not know what a probation violation is? I don't have the file in front of me, ma'am.
Yeah, we separated from the morning from the afternoon because we had so many afternoon.
It says the violation has been dismissed defendants in Eaton County. So I'm wondering if she's trying to reset. It's a new probation officer and I'm not familiar with the codes that they're scheduling with.
No.
So would that be the only thing bringing you, because I don't know if you'd be here for the sentencing on the OWI.
Yeah, it was sent the PSI for that, Your Honor, which I was excited about because when I used to code a 54, we didn't get those, so that was exciting. And if you would like me to be present, I can.
I don't see a reason unless you hear from us that we need you for some reason.
Okay.
Okay.
I could be available. I could give you my cell. Or
Yeah, give Wendy your cell
Like
phone
me.
and yeah.
Okay, thank you. So I'm more than happy to at the party.
Yeah. Let me take it. We'll look at the file over lunch, but
Okay.
I don't
And
think.
again, I'm more than happy to. I'll just be at the
She
office.
does it to Ms. Gallagher, so she does have to say no.
All right, so you're Tyrese Williams?
Yes, Your Honor.
All right, we're on the record docket 22023262. And that's the people of the state of Michigan versus Tyrese Williams. This is set for probation violation arraignment. So, Mr. Williams, what I'm going to do is I'm going to tell you the nature of the probation violation allegations that have been brought against you. And then I'm going to explain to you some of those rights in this matter concerning a hearing in this case. So in a request and summons for probation violation that was signed on January 30th, 2023 by Jody Bayless, signed by myself on February 1st, 2027 in response. In the request and summons, it alleges that you'd committed the following technical probation violations. In the first violation, you failed to refrain from alcohol as directed per AberHealth. On January 23rd, 2023, a positive sample was submitted, yielding a positive result. On January 23rd, 23, the defendant did admit to this officer, Officer Bayless, that you consumed a beer on January 22nd, 2023. That's the nature of the probation violation that's been brought against you. Do you understand the nature of the probation violation, sir?
Yes, Your Honor, I do.
All right. You are entitled to a hearing in this matter. And in that hearing, you're entitled to representation from an attorney in this matter to contest any charges or cross-examine anything that has been brought against you. You're entitled to a hearing within 14 days, and you're entitled to have the public defender's office at least represent you as they did in the underlying file. I believe you were represented by the public defender's office. Are do you plan on to seek representation from the public defender's office in this case?
No, Your Honor.
All right. Do you plan to represent yourself in the case?
Yes, Your Honor.
All right. Have you had the opportunity to speak with your probation officer, Ms. Bayless, concerning the recommendation?
Yes, Your Honor. I spoke with her, and she had told me that she was not recommending jail time, that she said that she were more than likely and that she probably will extend my probation or offer some alcohol classes, Your Honor.
All right, that's my understanding, sir. So is it your wish today to plead responsible? And it is the court's indication that is the recommendation. So I'll follow the recommendation. Is it your request today to plead responsible to the probation violation?
Yes, Your Honor.
All right.
Is there anything that
Go
I
ahead.
can?
Go ahead, sir.
I just wanted to say that I know that I was in the wrong, and I do want.
Let's have you plead to it first, and then we can talk about it. All right.
Yes, Your Honor.
All right. So I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. There's the violation consists of really one aspect of it, and it's that you tested positive for alcohol in violation of your probation, and then you admitted that you had a beer to your probation officer. Do you admit to both of those allegations, which are really the same allegation concerning this probation violation?
Yes, Your Honor, I do.
All right. I find the admission to probation violation to be knowing, voluntarily, and accurately made. I'm going to go ahead and adopt the recommendation at this time. So admits to PV at arraignment. And the probation officer's recommendations adopted. So, sir, you can go ahead and tell me what you were going to tell me before, Mr. Williams.
Yes, Your Honor. I'm sorry. I wanted to let the court know that I did pay off my court fines and probation fines and my restitution. I'm back on track. I have been going to classes. I have been dropping like I'm supposed to and have been clean. I have not been using. And I just wanted to apologize to the court. And I am working. I am a manager at Sir Pizza. And I'm working very hard. I do have children. And I'm just struggling a little bit trying to get into this, like the court system, as in like, basically like trying to like get on track of everything, as in like going in to drop every day and going into classes. Like it's kind of like new to me. And I just wanted to let the court know that I do apologize for my wrong behavior. And as you see that I did admit to the probation officer what I had did, because I wanted to be truthful to her. And I did not want to start off as a lie.
All right. Well, thank you, Mr. Williams. You've been first of all, you're an excellent candidate for probation concerning these matters. You're employed, your balance is zero. I don't have any issue. Your probation violation in itself is pretty minimum, but I appreciate you coming forward and indicating it to the court and your candor with the probation officer. The only thing that it appears that the probation agent is adding is a 12-step meeting, one per week. And then if no violations for 2 times a month, that you can revisit that with the probation agent. It seems that you've already talked to the probation agent about the majority of this. So I'm going to tell you, but for the drinking that is the form of this probation violation, you need to do what you've been doing in addition to the 12-step program that's been added. Because right now, so far, the way I look at this recommendation is that you've performed excellent as far as your probation, but for this one slip up. You had one slip up, and it sounds like you have a full understanding of it. So I'm going to continue your probation as it is. I'm not going to add any amount to the probation at this time. There's 12-step meeting per week, and then revisit that with your probation agent. I would just keep doing what you're doing. Anything your probation agent asks, which all seem to be reasonable to me, I would just stay in line with that. And and you're not a kid, so I'm not going to talk to you like a kid. You're a kid. The key here is to get this behind you, right?
Yes, Your Honor. And
All right.
I told the probation officer that, I did have a slip up and that was my mistake. And yes, I did admit to my wrongdoing.
All right. Well, keep in touch with your probation agent, Miss Bayless, and we should all be set today. All right, Mr. Williams?
Yes, Your Honor. Thank you so much.
All right. Thank you. So that's all for the record, 2202362. Mr. Williams, good luck to you, okay?
Thank you.
And sir, on the cell phone, would you identify yourself? Sir or ma'am on the cell phone?
Shamaria Brown.
Shamaria Brown, and you are here for your probation violation arraignment, is that correct?
Yes.
All right. All right, we're on the record in docket 2100407. All right. Yeah, Ms. Brown, what if you would take your listening device off speaker? We might be able to hear you better because we're getting feedback.
Okay. There it go. Okay. Can you hear me?
Oh, I can hear you much better now. All right, so this is the time set for a probation violation arraignment in regards to your case. So I will indicate the nature of the allegations that have been made against you by your probation officer, and then we'll talk about your rights at hearing. So it is alleged by probation officer Brendan Hanna on February 3rd, 2023, signed by myself on February 3rd of the same day of the same year, that you violated your probation in the following manner. Violation: failed to make monthly payments on fines and costs, that no payments were made. Second violation is failed to provide verification of completion of 100 hours of community service. Those two are the nature of the violations. Ma'am, do you understand the nature of the probation violations that have been brought against you?
I understand.
All right. You have a right to a hearing within 14 days of this date of probation violation arraignment. You have the right to counsel in this matter and to contest any charges brought by the people of the state of Michigan in regards to these probation violation matters. Were you represented by the public defender's office in your initial underlying charge? Do you plan to seek representation from the public defender's office in this charge?
No, because I was just hoping that I could, because I've been having trouble. I haven't had a job for long. So, and I just moved into a different house because I was going to be homeless if I didn't. But I was hoping that I could make a payment today and get what's it called? Community service. I got, like, the house that I was living in on Shiawassee, they locked me out. So half of the community service that I did and I had wrote down was in that house. So I couldn't get nothing, retrieve nothing out of that house. But I got the ones that I have completed here at this house. I just got my boxes and stuff out of storage.
It's my understanding that you have, how much of that community service do you have left, ma'am?
I completed it all. I just completed it all because when I talked to him, I had like 10 hours to complete and I had just finished that.
All right. And then you have my last indication is you have a current balance of $635, which is the amount of payment. And you wanted to make a payment towards that today?
Yes.
All right. So let's do this. Let's set this for formal hearing. All right. I'll give you the opportunity to go to the public defenders if you want, but that we'll put it 2 weeks out for formal hearing so that you can make any payment that you need to and get that done so we can bring it back to hearing, and then we can decide what our options are at hearing in regards to, and then if you can always call the public defender's office and talk to somebody there if you want representation. But I think I'd rather see this in 2 weeks from now, once you've made a payment on the balance. Yeah, and so once you make a balance, a payment, so that I'll have all the information, and that'll guarantee that we can look at this. Have you talked to your probation officer about this violation?
No. But I know I told him that I would be trying to make a payment. It was just hard to do that with having to pay $3,000 to move and extra costs to get the truck and stuff to get in the house and pay the utility bills that I needed to pay. So I told him I was going to try to make a payment. Yeah.
Have you turned in any verification of that you've completed your hours?
I told him, and he had wrote some down because at first I was having trouble finding places to do it because they because of what's on my record, they wouldn't let me do community service there. So I started doing community service with my dad because he worked for the CATA station. So I started doing community service that way and documented them. And he wrote some down too. And then when I first started with the little girls club that I had joined, we had fed the homeless and stuff at downtown.
All right.
And that
so
was like
I'm going to set this within 14 days, and for just some time for Mr. Hanna to confirm your community service hours and then confirm that payment's been made, and then we'll go from there. So I'm going to enter not guilty for purposes of this arraignment, and we'll set the hearing out so that more information can come in by the time we get to address this at hearing. All right, ma'am?
Okay.
All right. So what's the hearing date that we can set this for?
February 28th at 1:30.
Okay, so it's set for February 28th at 1:30.
Okay.
And in the
February
meantime,
28th, 1:30.
February 28th at 1:30. Let's hold that live. So come to the 6th floor and make sure that the probation officer has some type of confirmation on your community service hours, and then at least you have some confirmation of the payment, and then we can go from there. I think it looks like this case is looking towards a resolution. So, but I want to make sure that I want to make sure I have those things for the file before, so that we know how we're going to go forward next. All right, ma'am?
Okay.
All right, so February 28th at 1:30, you want to confirm your community service hours and your payment, and we'll see here on that date. I have a number for the public defender's office if you want that, or you can look that up, but I can give you the number right now.
For the same lawyer that I had?
Yes.
I have his number.
All right.
But
I
don't think I
But
need
if
one.
you don't feel that's necessary, just make sure and confirm your community service hours and your payment, and we'll see you on February 28th at 1:30.
Okay.
All right. We'll see you on February, Miss Brown.
Yep. Thank you.
Thank you. You're all set.
All righty.
Mr. Beck? Sir Jonathan Beck? If he does.
We're ready for the sentencing on Mr. Powers.
You want to go on Mr. Powers?
Sure.
All right.
Mr. Powers, you want to come on up?
All right. We're on the record in docket 2021-01274. That's people of the state of Michigan versus Michael James Powers. Will the parties please introduce themselves for the record?
Aaron Robinson, Assistant Public Defender for Mr. Powers, who's standing to my right.
And you are Michael J. Powers?
Correct.
All right. This is the time set for sentencing. Ms. Robinson, have you had the opportunity to go over the pre-sentence report with Mr. Powers?
I have.
Any additions, deletions, or corrections?
There is one correction to be made. It does say that he's currently working at Amazon, but he is now working at Arby's. So just need to change that.
All right. And how many hours a week is that at Arby's?
I'm accumulating approximately about 60 hours a week.
Okay. All right. With that correction, you've had the opportunity to go over the PSI with Mr. Powers' allocution.
Yes, Your Honor. I've read the pre-sentence investigation report, and I do agree with the conclusion in this case. I do believe that the incident in which Mr. Powers is here for today was something that was a poor decision on his part, that he expressed remorse for that and understood the seriousness of his actions. It appears that he doesn't have a substance abuse problem leading to dependency issues at this time. And I believe that the recommendation of him completing the victim impact panel within the 90 days, as well as the alcohol education class, I think would be a good outcome for him. I have spoken to Mr. Powers. He is remorseful. He does understand the seriousness of his actions and is doing what he can to move on with his life and making sure that he doesn't make that same mistake again. So I would ask the court to recommend the recommendations stated in the PSI.
All right, Mr. Powers, anything you want to say to the court before the court passes sentence?
No, Your Honor.
All right, thank you. I agree with your counsel. It's a pretty good report, okay, as indicated. So this is count one of the guilty plea to operating while impaired was, I think, the ultimate operating while impaired 93-day and or $300. So I'm going to order spend 1 day in jail, credit for 1 day given. Okay, the fines and costs, understanding that there is no restitution in this matter. I'm going to set fines of $75 and costs of $75 for a fee of I'm going to get this right.
150 plus 125.
Yeah, 150 plus 125 is 275 as a total. 275. I'm not ordering probation. As per the recommendation, it appears that this was a mistake, that I think that the probation has seen it as a mistake. I don't expect to see you back here again. You were pretty candid about decisions being made and these being bad decisions. So at least on that night, then those are decisions that we all face. So I agree with counsel that part of this is you attend the victim impact panel within 90 days with verification to the probation department. I think that's it as far as the recommendation goes. Is that's it. Attend victim impact within 90 days with verification. And I will sign that order. So as long as you do the 90 days, attend the victim impact panel, which is the only thing that was recommended, and pay the cost of $275, we can put this behind us. All right. All right. Anything for the record, Ms. Robinson?
No, Your Honor, but I did tell him to contact Ms. Dahosky I guess, who is the person at probation with whom he talked to get information on how to sign up for
The impact.
the victim impact panel. So I just wanted to confirm with the court that
Right.
you should contact probation for that information, correct?
Correct. Then probably do that within 40, that usually we send them down, we send you down to recontact as part of probation. In this instance, you're getting there to make sure you get the impact panel so you can get it back to them. All right. So I would do that within 48 hours. If you can, you're already here, you can do that today. All right. And just get it done, get it done and out of the way. Anything else, Ms. Robinson, on file 21-01274?
No, Your Honor, that's it. Thank you.
All right, Mr. Powers, it's a mistake. It's an expensive mistake. You probably have better things to do with your time than be here on a Tuesday afternoon. Good luck to you, okay?
Thank you. Your Honor.
Thank you. I said CGOI.
Yeah, this one, because he's not getting probation.
Okay. I can't say that on that one.
Yeah, so he needs to pay 275 by 90.
Back to the last. How about Mr. Oski? That's the resentencing, right?
He should be downstairs.
All right. Initial that.
Yes, please.
He was in.
Just bad decision.
Yeah, and he drives home and gets to the county, gets him. He's a point away. Just fires nothing. Admits to everything. And Ms. Williams and Mr. Austin, you're here on the Jackson case.
Yes, Your Honor.
All right.
Oh,
Let's get through these. Mr. Oski's needs to be brought up. Or are they gonna put him on a polycom? Okay,
he's in person. You should
you gotta resentence him
ask him. Travis. Oh, yes.
and then we'll just wait until the end of the day.
Usually should.
Well, I don't think he's coming.
I
I don't think he's gonna join us. And is Oski represented? Or is it just a resentencing?
It's a
for the
reason.
probation officer?
Mr. Austin was his original. Since he started.
Do you remember Mr. Oski, Mr. Austin?
Yes.
All right, are you here on that, or are you?
I am
It's
not.
just a resentencing because he's doing time in Eaton County. So they've asked that he just gets credit for all that,
Okay.
you know, because there's no reason to put him on probation because he can't report for anything because I think he got a year in Eaton County. So,
That makes sense.
yeah.
Yeah, I remember. Mr.
All right. Well, having you here might make him feel better about being resentenced today.
I'm gonna talk to Mr. Austin about Mr. Bell.
All right.
And I know he's at. Mr. Austin, do you have a quick second?
Sure.
Please.
So currently,
I was gonna say, when do we even sentence Mr. Matsky? I don't even remember this, not that I remember them all.
I don't have him as ever being sentenced. Not on the JOI. Not on the, it was set for November 21st.
But I guess
But
why you
then-
signed a judgment. Yeah. You signed a judgment,
On November 21st.
so we must have sentenced him.
I just didn't make any note.
Your Honor, are you talking about Mr. Oski's?
Yeah.
sentencing?
We did sentence him, right?
That is correct. My notes reflect that sentenced to a term of probation for 12 months, standard terms and conditions. And essentially, the goal was to replicate whatever Eaton County was
Right.
having him do.
I just didn't, for some reason, I didn't
And
sentence on 2022.
sentenced to, I think, 28 days in jail, the balance to be held upon successful completion of probation.
Right.
So
So what's June 1st? How many days is June 1st? And that puts them up before.
from November
Yeah.
21st.
Yeah, with credit.
1 second. My magic calculator over here.
That way we don't duplicate anything and
It'd be 192 days.
okay. He has 28 days previously served.
Yes.
So that's minus 28,
Yes. Math is not my thing yet.
170.
Okay. Judge. He made my head math facility yesterday.
I know, mine too. Oh. Credit for 28 days. Previously served. We'll give them time to get out. Because you'll have to take Mr. Oski back. Terminate probation. I gotta do is,
You might wanna wait to find the
yeah,
time.
I already, I did the first time, so,
You gave him fines and custom the first time.
didn't
Yeah.
I? Yeah.
360 oversight, crime victim.
Can I waive something? 75 and 50, I
You
can't waive.
can't waive it, but you can administratively close it.
That's what I'm gonna do. So that's 125 ACMC.
Yep.
And then I'll waive all the additional fines. and fees. Actually, I'm glad that Go ahead and come forward, Mr. Oski. Right, we're on the record in docket 22-02402. It's people of the state of Michigan versus Travis Oski. I'm sure you are Travis Michael Oski?
Marcel.
Travis Marcel Oski.
Yes, sir.
All right, thank you. This is the time for it set. What we're going to do is resentence you, okay? We're going to resentence you because you've been sentenced in Eden County. My understanding is your next out date is scheduled for July 13, 2023.
I'm doing all the programs that
Okay.
they have to offer there.
All right.
And so I will be, cross my fingers.
Right.
May 11th.
May 11th. All right. So in regards to the May 11th date, let's do May 1st then. So I'm going to resentence you so that this case coincides with the case you're currently doing. So you don't have any overlap. You can't report to probation because you're incarcerated, so it doesn't make any sense. All right. So
about that.
yeah.
Yeah.
Okay. So it's 161 days. So what I'm going to do is from the sentence from November 21st, 2022, I'm going to resentence you today, which is February 14th. I'm going to sentence you to 161 days with 28. You got credit for 28 days.
Okay.
So 61 minus 28. So you have $133 days, which we have calculated to May 1st. Okay. Which would get you out on this before your end date on your Eaton County case.
Yeah.
Okay. So on May 1st, which means that that'll set you up. So your end date there is your actual end date. Okay.
Okay.
I'm going to waive any fines and costs in this matter. I can't waive a $75 fee and a $50 fee. That's $125, but I can administratively close the file. So you won't be responsible for that. I can close the file, which I'll do. All right.
Okay.
So, and I'm waiving any more fines and costs. So the sentence would be to 133 days. And your out date, which would put your out date on May 1st, which would be before your May 4th Eaton County out date.
Okay.
Just so with the recognition that that's how we can run this thing concurrently and still efficiently. All right. Okay. So that's the new sentence of the court is to sentence you to 133 days, out date on May 1st with this credit for 28 days. Yes.
I think it'd be 161 days, credit 28 days, that leaves the balance of 133.
Yeah, balance of 133. So an out date, that should be the out date of May 1st.
Yeah, that's what it calculated.
Okay, perfect. All right, and that's what we needed to do here. We needed to writ you out to make sure that this coincided with Eaton County. So your out date there and your out date here is the same.
Okay.
All right.
So will I report to probation when I get out?
None. Your probation's terminated. You're off of probation. Yeah. So this sentence is just jail time that'll run concurrent with your present Eaton County sentence.
Okay.
All right.
Thank you, Mr.
All right. You're welcome. We're all set.
Thank you.
Okay.
I appreciate you.
All right. I think it makes sense. Well, I think my notes make sense too.
Let me read that.
Just make sure. We'll wait for Nathaniel to get back up here and then we'll start on the next hearing, okay?
Please, thanks.
Mr. Powers this file.
I sent you an email so that they're in our office.
Oh, well, there's that PVA. He
Oh,
said he was here
sorry.
for a sentencing,
So
so.
hang on, you can have this one too.
Okay.
Three. I just wrote it in English.
Okay. That'll work. How you doing? Haven't seen you in a while.
I'm well, and you?
Yeah, not too bad for a Tuesday.
Ms. Murphy, Mr. Austin. Due to I don't know why. County has put Mr. Jackson on for Polycom instead of bringing him in person. Judge said just to leave it. We found out this morning.
Saw that.
I don't, I put him on the list in my defense for the right thing. So, and now he's not appearing on video yet, so I'm going to contact county and see where he might be.
Okay, sounds good.
Right before the vote too, so.
Yeah, I know.
Yeah.
Yeah, but
That's true.
I mean, I filled out the forms and everything. but-
Oh, it happens a lot. I mean, it's, yeah, it's okay.
I know, but usually when I do the jail list, it gets messed up.
Oh, that's a happens.
That's Nathaniel's baby.
03542. That is people of the state of Michigan versus Saban W. Jackson. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Crystal Murphy on behalf of the people.
Good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Jackson, filling in the counsel of record, Mr. Sartz. Mr. Jackson appears with us today at council table. Also appearing with us today at council table is Mr. Foreman, Mr. Jonathan Foreman from our office as well.
All right. And sir, you are Saban W. Jackson Jr. All right, thank you. This is the time set for a motion in this, and just by way of how we got here. There was, this was set for motion. The motion was filed by Mr. Sartz, who you're covering for. Is that correct, Mr. Austin?
That is correct, Your Honor.
And that was a defendant's motion dismissed due to speedy trial violations, abuse of discovery. I do have the response filed by the prosecutor's office, and you have a copy of it, Mr. Austin?
Yes, Your Honor. We
All right.
received that via email.
And that was filed in response. So I know that Mr. Sartz has made a fairly lengthy argument concerning the motion for speedy trial. I wanted the prosecutor to have the opportunity to respond and then to address any of the discovery issues that were set forth in regards to the case and the lack of discovery in the case. And this it was with Mr. Wisty, who is not in a position to answer questions, and I don't think Ms. Housefield was. So Ms. Williams, I'll give you the opportunity to respond to the motion. You had the opportunity to read the motion?
I did, Your Honor.
Okay, so I'll give you the opportunity to respond on the record to, and I got to read your response to the motion for speedy trial and dismissal. So I'll hear anything you have to say in regards to the response.
Thank you, Your Honor. I primarily rested my response, but just to add briefly as it relates to discovery, we have that all straightened around now. This was a situation where a lot of miscommunication occurred. There, to use a lack of a better phrase, too many cooks in the kitchen, so to speak. A lot of miscommunications, a lot of missed things that were going on. But basically, when I had an opportunity, when I got out of trial, because as the court read in my response, I was in a CSE trial. When I got out of trial, I was able to make phone contact with Mr. Sartz. I was able to figure out specifically what he believed to be missing. The two paper documents, I believe it was the last page of the search warrant that he believed was missing, resent him that. The drug lab, the MSP lab, got him that personally. I personally emailed both of those things to him. And then the unfortunate remark that was made by a member of the prosecutor's office regarding things been deleted, it was simply incorrect. That was found, both the in-car and dash of that particular incident of the arrest was found.
That's the video, correct?
Yes, that is correct. And then in terms of body worn camera, from what I can tell, because this case is a reissue, from what I can tell, of course it wasn't there. Well, initially when this case was first before, I believe it was Judge Clark, a different judge, there appeared to have been arguments and a motion to compel body worn camera. Body worn camera never existed. Never existed the first time. It doesn't exist now. I reached out to Detective Sergeant Ray Durham via email. That was noted in my response. He responded to me fairly quickly. I believe it was the 9th, February 9th, stating, no, we have never had body worn camera at this unit. From what I can tell, this was just a series of miscommunications and not going directly to the source, even in the very beginning case and even now. The statement made by the individual about things being deleted wasn't correct. What we have is what we have that's been made available to defense. Body worn camera simply does not exist. We don't have it. The police don't have it. That particular unit being an undercover drug type of unit, they weren't wearing them. So discovery is totally, that's been fixed. There's no issues as to that. Of course, I apologize on behalf of the prosecutor's office for that mistake made by the individual. That's fair enough. A defense attorney sees that, they're going to be concerned, but that's been cured and is okay. As it relates to speedy trial, actually, Your Honor, I found a case and I'm more than happy to send it to Mr. Austin, because I actually found it while we were sitting here. People v. Polzin, it's an unpublished case, Court of Appeals 2018. It actually goes directly to the issue of reissuing a case. And before I kind of go into that, with the court prefer, I can email it to Mr. Tossin.
You can talk about it and reissue the case, but I
Okay.
mean, you can talk about it and then we'll take a look at the case. But I'm as an officer of the court, you can give me an offer of proof as to what you believe the case says.
Sure. Okay. Thank you, Your Honor. Basically, this deals with a case that was reissued, similarly to this one. And the court talks about how the lower court dismissed for speedy trial. And there was an analysis as it related to, I believe it was a North Carolina case. And then they went into the analysis of what nollie pros means in the state of Michigan. And with nollie pros in Michigan, it doesn't mean that once the case is dismissed, that then it's just continued on forever. It's dismissed. And then the prosecution has to bring a new case. And then typically arrest is kind of where things kind of kick off in terms of timeline and time frame. This defendant was already incarcerated on other matters. He was already in custody. Once the warrant was sworn to, he was arraigned, I believe shortly thereafter. So essentially, the people submit to the court speedy trial. It's not going to kick in here because this was it's a newly brought case. Now, of course, if this was ongoing, like whatever the statute and laws in North Carolina from 2019 up until now, yes, we'd have a huge problem. That's not how it is here. And like I said, of course, I'm happy to email a copy of this both to Mr. Austin as well as the court.
All right. I'll have, and I know this is Mr. Sart's case, but Mr. Austin, if you want to respond, I will indicate, I've always looked at this as there was a sense of frustration for lack of discovery because it was dismissed on lack of discovery from the 1900566 case, and then it was reissued, and then there was a frustration for lack of discovery. I don't think there's a right to a speedy arrest. I don't find a right to a speedy arrest. Once there's been issued, there is a right to speedy trial. And of course, this kind of combined with both discoveries was a problem that, which seemed reasonable to me, that we don't have a cross-examination when Mr. Sarts doesn't have the information necessary in order to have a valid cross-examination. That was the sense of frustration I received. I did read Mr. Sart's motion. Any response, Mr. Austin, in regards to what the assistant prosecutors indicate?
Yes, Your Honor. There's a few things that I want to add and say in response to that. I know Mr. Sart's filed a very thorough, I think, brief and memorandum of law on the issues as they pertain to this matter. And Ms. Murphy is correct. In some respects, there have been some updates in terms of the discovery and some additional stuff that has now apparently been turned over that we didn't have at the time of the filing or at the time Mr. Sarts filed that. However, I would respectfully disagree that I think that resolves all such discovery issues for a few reasons, Your Honor. One, with the MVR in-car camera that has been apparently turned over, obviously Mr. Sarts has not had a chance to see or review that yet, but apparently, according to Ms. Tusco from the prosecutor's office, there were some phone dumps that were either found or recently provided as well. I don't know if either party were aware of those prior. The ongoing issue seems to be, Your Honor, just in the last week or two, there have been numerous contradictory responses to these discovery requests and demands. It's, well, there are no more issues. Those have been resolved. That was previously stated. Then it was stated by Aaron Galloway at the prosecutor's office, the in-car camera that they're seeking and so forth had been destroyed and no longer exists. Now we know that is no longer true because they have recovered that and apparently something additional. So the statement that discovery is complete or we can't turn over the body worn cameras because they don't exist, they never existed. I think the problem with that, Your Honor, is how could we know that for certain? because of the contradictory responses that we have received as to what discovery exists, what didn't exist, or what used to exist and now no longer exists, and what has been provided or turned over, and so forth. So to say that that has been fully complied with and that is complete, I think at this point we wouldn't be able to say that, or we wouldn't be able to completely determine that, because there has seemed to have been a lot of confusion on the ones who would be the custodians of this particular discovery. So how can we be certain that it is all complete, or how can we be certain that something wasn't lost or destroyed? And this overlaps, I think, Your Honor, with the speedy trial claim, which Mr. Sartz also argued and briefed at length in his filing and pleading to the court. The reason why one of the factors when looking into a speedy trial claim is the length of the delay is for situations just like this. This wasn't a case, Your Honor, where there was a dismissal and it was reissued within weeks or even months. This is something that was reissued nearly 3.5 years later. This isn't a situation where the case or the investigation was ongoing, or some new witnesses came forward, or they had tested some piece of evidence that they hadn't previously tested before that may have resulted or prompted them to refile the case. That doesn't appear to be the case here. This sat dormant in a dismissed state for 3.5 years almost, and was then reissued, and there doesn't seem to be necessarily any good rhyme or reason for that. And that puts us in the situation that we're in now, where so much time has passed. Not only has memories faded from the original participants, including the original parties to the case when it was originally issued and dismissed, but also in terms of witnesses, but also in terms of discovery. This has been so far removed from the reissuing from the time of the dismissal. This is why I think a great reason as to why we're having the issues that we're having in terms of what discovery do we have, what discovery did we used to have, but we no longer have, or we had this particular discovery, we think, and it was either destroyed or no longer available, but now it turns out there is. And that just begs the question, I think, Your Honor, is what else like that may be out there? And I think that goes to the Brady claim, and I think that goes to the speedy trial claim for the unusual length of the delay between the dismissal and the reissuing. And again, there doesn't seem to be a particularly good reason for that. And the prejudice comes in by the exact situation and problems and arguments that we're having now as it relates to discovery. Some more updates that I wanted to update the court with, Your Honor, because this is in terms of some things that Mr. Sartz made in his pleadings, as well as Ms. Murphy's response that I don't think may have been known completely to either Mr. Sartz or Ms. Murphy at the time of those pleadings. I had the court pull the 2019 file because there was wasn't necessarily an assurance that the original counsel of record had filed any discovery demands beyond just a generic appearance. That's now been confirmed from review of the file. That was the case. There were specific discovery demands, and there's specific discovery demands as it relates to the discovery that we were seeking now. In this case, there was a demand for a speedy trial in that pleading as well. And there was apparently a motion to compel some of the exact same discovery that we're having the issues on here. And I think that is very significant. It's a little unclear from the record as to exactly why that case was dismissed, Your Honor, without prejudice, but I would have to believe that that played some kind of factor, maybe even a very significant factor in that, which again, I think goes along the speedy trial argument and then overlaps with the Brady claim as well. They can't restart the clock for speedy trial, Your Honor, simply by reissuing the case and to say the speedy trial clock starts again. If that were the case, Your Honor, then all the people would have to do, if they are somehow running afoul of a defendant's speedy trial and it's getting close, then all they would have to do is just dismiss the case and reissue it and the clock starts over. That can't be right. So I think we have to look back at that original arrest period, which would have occurred sometime in 2019, the charging and the arrest when doing the speedy trial analysis. And then again, Your Honor, we have all this significant passage of time, and we have all of these issues and these inconsistent statements regarding the discovery that we would not have had if they wanted to reissue the case, been reissued in a more timely fashion. So again, Your Honor, I think that the speedy trial claim and the Brady claims are still very much valid for the reasons. I don't think the people made a specific response to the speedy trial claim in their response of pleading. They seem to mainly focus on the evidentiary issues, the discovery issues, the Brady claim. There was certainly no mention, I don't think, of any unpublished case regarding speedy trial, which, as the court is aware, is certainly not binding on this court. But that is the extent of our argument, Your Honor, and I would certainly welcome any questions the court has, either as to the timeline or to the legal arguments.
Right. Thank you, Mr. Austin. So here's the, and I'll let the prosecutor respond. So it's as if the court is we're trying to understand what happened in 2019. Okay. So that's essentially, I have a motion from the people to dismiss the moves for nollie pros in the interest of justice, and it's granted without prejudice from Judge Clark. I can only speculate what came before them. Okay, I really can. It appears that it says because of the interest of justice, it's signed by Judge Clark. There is a motion to compel discovery by Joseph Yang, who was the attorney of record. There's also an ex parte order of discovery from Judge Clark, indicating a series of at least two any video regarding the alleged confession that seems to be as cured, and then an answer as to body worn cameras that seems to be answered in regards to they were not in existence. Those two seem, but I do think counsel raises a valid point that as of 2019, the case is dismissed and then it's reissued and arraigned on 2022, and then we have somewhat the discoveries issue, but not a large. I don't think it's a large time frame for a felony. I mean, this was the probable cause conference was initially held on January 13th. It was arraigned on December 21st. Today is, of course, Valentine's Day, February 14th. So we're into the case 6 weeks, maybe 7 weeks into the felony case. But I do want a response as to that's fine. But if we put the time frame together, 2019 with 2022, well, we're looking at the case that's been reissued after discovery, after it was dismissed for discovery issues. And then we have some unpleasantness with the discovery issues. So I guess I'd have Ms. Williams answer to that response. I think that's a fair and reasonable question to say, all right, let's assume that we go from 2019 to 2022. What we've done here is we've reissued a case that had discovery issues, and then we have some of the same discovery issues, but we waited 3 years to do so. So the prosecutor's response to that argument.
Sure, Your Honor. And in terms of speedy trials, the court knows the main factors, one, the length of the delay, as the court just noted, the reasons for the delay, whether the defendant asserted his right to a speedy trial, and for prejudice to the defendant from the delay. It's Barker v. Wingo, 407 U.S. 1972. Also to the unpublished case law, yes, it is not binding, but it is certainly a case that the court can look at for persuasive factors. This was not, and I'll just echo a little bit of what I said previously and not repeat it in too much length. This was not an ongoing case from 2019 up until now. There was one case, it was dismissed, and now this is a new case. It was brought anew. With the discovery, from what I can tell from speaking with Detective Sergeant Ray Durham, from kind of gleaning off of previous notes, it seems that this case was dismissed previously off of lack of body worn camera. That's from what I can tell. Of course, I was not there. None of us were there. But from what I can tell, it seems to have been the case that it was dismissed for something that never existed. It was unfortunate that there were so many miscommunication issues here. But certainly, if the court allows for us to come back on a new date and finish the exam, I'm happy to subpoena the individual in the prosecutor's office. I'm happy to subpoena Detective Sergeant Ray Durham, who can kind of speak to some of the processes and why things were or why things weren't, if the court wants me to. But at this point, Your Honor, there's no procedural advantage that people have gotten here from this. What Mr. Austin stated on the record are the same issues that the people are going to have, potentially lack of memory. But this is a situation where we're not so much dealing with civilian memory, things of that nature. We're dealing with of course, officer memory, which can, of course, fade as well. However, we have drugs that were seized, we have guns that were seized, and I would just say this is a little bit of an aside. I would just encourage any defense attorney to speak directly to the assigned prosecutor on the case. I think that would create a lot of, it would cut down on miscommunication issues. So if Mr. Sartson went directly to me, I think would have been a lot simpler. This, of course, is not directed at Mr. Austin because he's standing in. But in regard to the length, Your Honor, there's nothing specifically articulated by defense that the people are getting some type of perceived advantage over bringing this again. Anything that would potentially be detrimental to defense in terms of evidence, memory of witnesses is going to be the same issue that the people have. This is now a situation where we meaning me, I have talked with people, figured out what the issues were, figured out what the problem was, and the problem, from what I can tell, began with something that never was in existence, that being the body worn camera. And now we're, of course, here today. That's the issue. People have no perceived advantage bringing this again. There's no gain. There's no new things that are going to come about where we're talking to new witnesses. It is what it is. It was a drug raid on a house. Drugs were found. Guns were found. Statement was made by a defendant. It's pretty black and white in that sense. No new additional evidence is going to come forward in terms of that. So unfortunate miscommunication issues here, but no advantage for the people in bringing this again. And in terms of it being refiled, it's brought anew. It's not an ongoing case from 2019. So with that, Your Honor, I would just respectfully ask that the court deny defendant's motion and allow us to continue this exam on a different date.
Thank you. Well, I do agree that the initial charge was brought in 2009 on February of 2019. That's when it's signed by Magistrate Milmore, I believe, on February 8th, 2019. From there, the initial case was nollie pros in June of 2019 by the prosecutor's office. That was the motion for nollie pros is signed by Mr. Coop, who was an assistant prosecutor at the time, on June 19th. I can only guess as to what led to that, but it appears there were some discovery issues on that case. And then we have an arraignment on a case that we've added some counts on, it appears. No, I think it's the same.
I don't mean to interrupt the court. I'm sorry. I think it was reissued, the new case, without the felony firearms, but we would be moving to add those on at the new exam. So I essentially it would be the same charges.
All right, and that was authorized on December of 2022, which is almost 3 years later. February 20, February 21, February 22. So the question then comes to the court, all right, what prejudice does that show? It was dismissed without prejudice, it was reissued. What prejudice is shown from the defense now to indicate that the case has taken on a different life and is now a part two of what essentially is the same fact pattern. I don't see a change in the fact pattern. And the prejudice that I've seen so far was still in regards to discovery, but discovery issues have been cured only as to what's been requested, and then towards a body camera that never existed, that didn't exist from the beginning. So it's a little bit of a different speedy trial issue, not a traditional speedy arrest issue. That being said, because the case in regards to the facts of the case are fairly straightforward, I don't see an identity issue. I don't see witnesses concerning an identity issue. We've saved cross-examination, so to make sure that discovery issues, any discovery that needs to be met, would be subject to the cross-examination of Mr. Sarts. So I'm looking at what prejudice, other than that we've had some time lag, what prejudice the defendant appears to have faced in regards to the fact pattern, that this was a search warrant and an admission made to the detective. The detective will be brought back for cross-examination. What discovery is made can be readdressed. So I'm having trouble with the notion of speedy trial in regards to the prejudice that the defendant suffered at this point in time. And I don't know if we're getting into, I mean, Mr. Sarts indicated we're past a year and a half. That's true in regards to two separate cases, but I don't know if that's been addressed with one case and then 18 months later in the same case. So it's novel that I see two files that are alike. I just don't see prejudice right now as to the defendant. I don't see the loss of memory of witnesses, since the witnesses are pretty much the admission and the video camera concerning the admission made. That'll be subject to cross-examination. And there may be witnesses at the house that'll dispute where things were found. That may be an aspect to this, but I don't know if that rises to the level of prejudice that's required to dismiss a case at this time. So what I'm going to do is I'm going to set this for preliminary examination with the understanding that now discovery has been made. There may be, as counsel indicated, there may be some phone dumps out there, and I'm sure Miss Murphy, and if I've been calling you Miss Williams, my fault entirely, okay? But Miss Murphy will look into that and will provide discovery, knowing that discovery has been an issue throughout this case already. But we will set it for preliminary examination. So we had the one officer on the stand when we adjourned, and that was Officer Dykers. He would be subject to cross-examination.
Correct.
All
Yes,
right.
Your Honor.
And then was there any other witnesses? Was there any other witnesses that the defense would like to be called from law enforcement in order to cross-examine for the preliminary examination?
Just a brief moment, Your Honor.
Yeah, and I know this isn't your case, so if you let the court know or let Miss Williams know, she'll make those witnesses available. Miss Murphy. I keep saying Miss Williams. I have no idea why. Okay. I don't think I had a Miss Williams in this courtroom today.
It's okay.
But I should give you the opportunity to speak to Mr. Sarts because I know this, in case there are any additional witnesses.
Yeah, and that's what I was just going to say, Your Honor. I would defer to Mr. Sarts on that. He did not specifically mention that to me, although I did not broach that particular topic with him.
All right.
So I would just, if the court could just leave that window open for a reasonable amount of time.
I think that's fair, considering the amount of time that we've put into the case, Miss Murphy.
Thank you, Your Honor. And I'll say this, I'm happy to sit down in person with Mr. Sarts and say, hey, I have X, Y, and Z number of things. Is that what you have? So we can kind of compare our lists and make sure what I have 100% is what he has. I think that would be the easiest, best, most thorough way to do it. And I'm more than happy to do that.
All right. So I'm gonna deny the motion for speedy trial. That motion is denied. I'm gonna set this for preliminary examination on just a regular preliminary examination date. That hopefully, do you have Mr. Sart's schedule, or I don't know if he's in trial or?
I can look it
All
up, Your Honor. I do know he does have some trials coming up. I will.
But it will be set on a usual Thursday or Friday, whatever the,
We could set it for Thursday, February 23rd.
so look at February 23rd for, and you should check your trial schedule also, Ms. Murphy.
I'm good for the 23rd.
Okay.
23rd appears to be a good date from what I can tell from Mr. Sart's calendar, Your Honor.
All right, February 23rd at 2:30. We'll set it for, I will allow the parties to, so there'll be a cross-examination of the officer, Officer Dykens, can't read my own writing. And then I don't know if you plan to call any other witnesses, but negotiate or at least talk to counsel to see what more witnesses may be available. I am satisfied with I don't need any more witnesses in regards to the file and discovery purposes. But I'm willing to entertain any more thoughts of discovery, like if the defense doesn't have it and they want it. It appears right now that any discovery has been provided.
From my understanding, Your Honor, yes, but I think it would be best, and I'm, like I said, happy to do it, to sit down with Mr. Sart's to go over everything, make sure he has what I have. Also, too, just given the circumstances, I'm more than happy if Mr. Sart's wants Detective Sergeant Ranger subpoenaed. I'm happy to do it.
All right. I'll leave that to you, Mr. Austin, after you speak to Mr. Sart's.
Certainly, Your Honor.
Anything else, Mr. Austin, in regard to this file?
Nothing else further on behalf of Mr. Jackson, Your Honor, other than I did anticipation bring a proposed order if the court would want to review and sign
Sure.
an order regarding.
Has Ms. Murphy seen that?
Not yet, but I'm
Okay.
about to show it to her. The only thing I haven't filled out, Your Honor, is the court's holding.
Okay.
May I approach, Your Honor?
You may. Thank you, Mr. Austin. Okay, for reasons stated on the record in regards to the speedy trial, and that could be observed, the court denies the motion for speedy trial. That it was issued. I'll sign it. I'll put it in the court. If you want a copy of it, you can get it from my court officer. Okay.
I would appreciate that, Your
All
Honor.
right.
Thank you.
So you'll have a copy for your file. All right. And then we'll set it for February 23rd at 2:30, and the parties will confer on additional witnesses. Anything else for the record in docket 22-03542, Ms. Murphy?
No, Your Honor, thank you.
Anything, Mr. Austin?
Nothing further back.
All right.
Jackson, Your Honor. Thank you.
That's all for the record in the file. Thank everybody for your appearance, and we'll see everybody on February 23rd.
Thank you, Your Honor.
All right. Thank you, Judge.
Mr. Austin, if you want to hang on for just a second.
Sure.
Ms. Murphy,
yes.
did you want a copy of the order as well?
Sure, I'll take one, yeah.
It's Miss Williams today.
I was gonna say,
It is.
I'm not sure. I think you're still stuck in yesterday.
Yeah, I have no idea why I'm using that name. I apologize, Miss Murphy.
No, it's okay, it's okay.
All right.